Program is called capacity building because the Learned Judicial Academy and the Honorable Court is aware that there is a gap, right, in your transition from a law student to practice, and in fact even I face that. So they want you to get a brief idea of how do you transition to practice from a law student, because as a law student I'm sure all of you are mostly reading about a case law or provision, right? Especially I think most of you are not aware of how CPC actually works or how CRPC works, because that was the same problem I had when I was in law school, right? So when I read constitutional law, the judgments, it made sense to me. But when I read CPC, CRPC, I could read those sections, make notes, but I could never, envisage how does it work in a trial. So this training session is basically to give you a brief idea how these provisions work and some of the cases that I've done on how these provisions apply, the court's reasoning, and also some are Supreme Court judgments. Okay, so the first session was on Advocates Act, ethics, etc. And the second session was on trials in CPC and CRPC. But however, since CPC is a very, very vast topic, I wanted to cover CPC first. Alright, so any further questions before I start? Please let me know. Alright, please don't mind the spelling mistakes because these slides were made in the last moment. Alright, so how many of you guys are from final year? All of you. And the rest? Fourth year. Okay, fourth year, final year, it's almost the same, right? So, the first part I will take you to is the plaint. That's the genesis of a civil suit. Okay? Now, what does it say? It says, these are basic points to remember. You will read Order 6, you will read Order 7, you will say the plaint has to contain material facts, etc. But before that, the reason why I told you to collate your documents, arrange them chronologically, make your list of dates, decide the relevant dates is something that you will learn only in practice. And this is something my senior taught me when I was in Delhi. His name is Sanjay Upadhyay, he's a senior advocate, okay. And I think almost all the chambers in Delhi do this. This is something you will not find in the books. So when you get your documents from the client, please collate those documents, arrange them chronologically. Once you arrange them chronologically, put them in a file. Once that is in a file, start making a 2 or 3 liner about what that document is. Now, why is this important? It seems like a tedious and boring process, but trust me, and my colleagues are here, Ms. Somaya and Prerna, they will attest to the fact that this list of dates helps you all the way till the conclusion of the trial, and even if you go to an appeal or the case reaches the Supreme Court, this list of dates will be your document you will refer to. And why do I say that? Because if you notice, civil suits, they tend to be very voluminous. It's not like a writ petition where you file a writ, then you file a counter affidavit, it's this big, right? Eventually there are so many applications filed in a civil suit, it becomes voluminous. And thereafter you cannot read every page all the time before every hearing. You do not have that liberty or the luxury. So what does your list of dates do? It puts your entire case in a concise document, 10 to 20 pages. Every time there's a hearing, you can refer to those list of dates and be able to assist the court on what the dispute is exactly about. That's one of the primary reasons why list of dates is important. It helps you analyze the problem in a chronological manner. That way you will know what is happening. Sometimes, take for example, I'll go to that case, but I'll discuss about it. It was an anticipatory bail provision. When I was making my list of dates, I discovered that a provision in CRPC was not even enforced. Whereas even the court was of the opinion that provision applies. It's in the Bear Act also it applies. And that would have only been discovered had we not made the list of dates. Further, if you make your list of dates, the judgments arranged chronologically will help you understand the evolution of law. If you start reading judgments in isolation, you'll get a very confusing picture, because one judgment may say this, another judgment may say that. Especially if I would suggest you guys to read the judgments on anticipatory bail and try to understand what is happening, because there's a lot of change and you'll only understand that once it happens chronologically. Alright, so before you begin drafting your plaint, list of dates, very, very important. Now I'll start going to the provisions of why they start becoming important. Order 6, right? So what does Order 6 say? Pleading shall mean plaint or written statement. Order 6, Rule 2 states, pleading to state material facts and not evidence. Every pleading shall contain only a statement in a concise form of the material facts on which the party pleading relies for his claim or defense as the case may be, but not the evidence. Seems like a simple sentence, right? Now this is where again the problem arises. When you practice exclusively in the constitutional courts, Supreme Court, High Court, it seems like a blessing in disguise. Yes, it is a blessing in disguise. But until and unless you don't practice in the trial courts, you will not understand why this word is so important. Many times the pleading in Supreme Courts and High Courts mandate that you plead even your evidence. Whereas in a civil suit, you do not plead your evidence. You plead a material fact. That is the distinction in pleading between a civil suit and a writ petition. Right? There will be instances during your trial where you say this person is the son of A and B. Now, you cannot plead every document if you follow this, right? This document says A and B, this birth certificate, this transfer certificate. That's the reason why Order 6, Rule 2 is so important. When you say A is the son of B, every evidence then becomes important to that plaint. So that single line allows you to read 5 or 6 documents. That ensures that the pleading is concise. That is in a civil suit. Now, however, let's look at a writ petition, right? Because you guys will eventually come to practice very soon and you will understand that there needs to be a difference. Now in writ petitions, when you start drafting, every document in that list of days that you're relying on has to be pleaded. Otherwise, the court will not consider it. That is the fundamental difference between your trial court practice and your drafting in constitutional courts. The other mistake I've seen my colleagues make during my practice in both these forums are, many lawyers from Delhi or West Bengal, etc., who exclusively practice in Supreme Court and High Court, even I did that. I'm not saying I didn't make that mistake. They even write the case laws. I think some of you were there during the moot court yesterday, right? So in moot court you plead the case laws, that's a good thing. But please do not plead the case laws in your plaint. Now, why do I say that? First, you're not following the provisions of Order 6, Rule 2. You're pleading law more than facts when you're supposed to plead facts. But the fatal result of that is your opposing side will look at the case law. He will read that case law. He will distinguish that case law, and when you come for that hearing, he will say these case laws don't apply. Then you've already given your ace. That's why please do not write case laws. I'll cite you an example. I was doing a commercial suit. The other side filed an application for rejection of plaint, right? Now, their assertion was that this plaint should be rejected because this commercial dispute, the contract has an arbitration clause. If there's an arbitration clause, then the court does not have jurisdiction. What did he do? Fatal mistake, lawyer from Calcutta. He wrote all the case laws. I went home, read those case laws. In the end, I started distinguishing those case laws during the hearing. So these are things that you will not read in the books. These are things that happen practically, right? Now the other point of plead material facts, Order 6, Rule 2. Another point you should remember is, if you do not assert it in your plaint, the court cannot analyze it. If you say, I own this property by virtue of succession or something, but you do not say that I am the son of A, the court cannot frame an issue on whether you're the son of A or not, right? So, the Supreme Court In Shivaji, Balaram talks about this. Can you see this? Is it readable? So it says, it is these issues which were gone into by the two courts and were concurrently decided by them against the respondent. These issues, in our opinion, should have been examined by the High Court with a view to find out as to whether these findings contain any legal errors so as to call for any interference in second appeal. The High Court, however, did not undertake this exercise and rather affirmed this finding when it did not consider it proper to frame any substantial question of law. Now listen to this line. It is a settled principle of law that the parties to the suit cannot travel beyond pleadings. So also the court cannot record any finding on the issues which are not part of the pleadings. In other words, the court has to record findings only on the issues which are part of the pleadings on which the parties are contesting the case. Any finding recorded on an issue dehors the pleading is without jurisdiction. Now see how fatal it is. You do not get this kind of, in civil suits, the anxiety, the nervousness stays till the end of the trial. And even when you go to appeal. Because there are these tiny defects which may in the end, destroy your case. Even though the facts are in your favor. So that's why you have to remember all these. Please do not take drafting for civil suits casually. You will get that kind of leeway in a writ petition. It's a lot more relaxed, right? So material facts, please remember, that's the reason why your list of dates again becomes important. Every list of dates you tick mark what is important for your case. You make note of those particular dates, mark it down and then you plead it. Right? So order 6 is that. Order 6 rule 2. Now are you guys understanding how practically CPC now works? Right? Because when you read it in law school, all you're saying is order 6, plead material facts. Let's go further. Order 7. This is the formal declaration in the code about what your plaint should contain. Right? Name of the court in which the suit is brought, name, description, residence, etc. I have highlighted E and F. Facts constituting the cause of action, facts showing the court has jurisdiction. Because these things sometimes become fatal to your case. Very, very fatal. Or even the court fees. Right? I'll go on to that further. So when you look at these provisions, please apply it practically. Think about it practically. Don't just look at these provisions as, oh, it's another, long list of things I need to do. I'll explain to you why. These are the points after culling out order 7, what you need to remember. Take note of limitation. I'll get to that also. Take note of whether you've pleaded that there is a dispute, right? That you've come to the court because some cause of action arose. Take note of jurisdiction. Whether you've mentioned that this court has pecuniary jurisdiction, that's the monetary value of the suit, whether the property is located in that area, whether the court has the jurisdiction to entertain the dispute, right? Because there are different kinds of civil courts also. Whether you've paid the court fees and whether you've served a section 80 notice if you've made the government a party. These 5 points, please keep it in the back of your head when you're drafting. Very, very important. Because these will lead to a dismissal of plaint later. I'll tell you how. Section 80. What does section 80 say? Every suit against the government, you need to serve them a notice and give them 60 days to respond. Now why did I tell you please take note of this in your plaint is because there are several instances where freshers have filed suits where government is a party without having sent the section 80 notice. Automatically a senior lawyer will come, he'll file a order 7 rule 11 application for rejection of your plaint and it'll get rejected. And then you have a difficult time explaining to your client that your case got dismissed on the first day itself, right? So therefore, if you see any government as a party, department as a party, and see, I'll tell you why this becomes important is, land ko case garse civil suits ma, right? Most of the times it's property disputes. Property dispute ma, some way or the other government is connected. Parcha dinuma, yata kema, verification ma, you will eventually make the government a party. So please note, section 80 comply garnu important ho. Please write it in your plaint also. Please calculate, keep the receipts. When you send the section 80, you will have to send it through registered AD, and those receipts are important to show proof that you've delivered it. Now, the exception to this notice is section 80 sub-rule 2. Why is it important? Is because, practically speaking, every time some encroachment suit happens, you cannot send a section 80 notice and think I'll wait for 60 days and nothing will happen. Things churn out immediately on ground, right? So if you send the notice or something encroachment is happening immediately, you need an exception. That's the purpose of section 80 sub-rule 2. It says if you have an urgent or immediate relief, right, the court, it may be instituted with the leave of the court without serving any notice as required under subsection 1. Now, what does it mean? Leave of the court means you need to file an application. When you file that application, then the court decides after hearing you whether this exception under section 80 is required. Section 80, you usually read it with a order 39 application for injunction. That's the reason why you're approaching urgently, right? You will not ask, oh, give me an exemption under section 80 just like that. You will show the urgency, and most of the time the urgency is because you will need an injunction. Now, this is what happened in our case, alright? So here was a land acquisition matter. The National Highways had acquired the land. Compensation was decided, money was kept ready, and then the dispute arose as to who's the actual owner of the land. The matter reached the High Court. I have not mentioned the case name. These are cases we argued. I don't know whether it should be prudent because the parties may go on appeal. The matter went to High Court. The High Court said that the proceedings under the National Highways Act has lapsed, but since there is a dispute as to the ownership of the land, let there be a civil suit filed. Right? But look at the reasoning of the Honorable High Court. You are supposed to file a suit within 1.5 months. Right? What does section 80 say? 60 days. Now here we have a problem. So what do you guys think? What should be done? This is not a formal training session. I'm a lawyer. You guys will also be lawyers. So be casual. Talk about it. That's how we discuss. That's when we move the section 80 sub-rule 2 application, right? Now what did we do in trial court? We came back to trial court. We filed the civil suit. We filed that section 80 section 2 application. We filed the injunction application. Eventually the court exempted that 60-day notice. It stayed the release of the money. Later on that order was challenged eventually in High Court, and eventually we won that order in High Court also. Right? Now, the other point that was important I told you about was to mention the jurisdictions of the court in terms of the location of the property, the subject matter, whether the court is competent to adjudicate on that, and the pecuniary jurisdiction. Why do I say that is, if you guys have phones, please look at your CPC also. I have just extracted this from CPC last night. So CPC, if you go to section 6, section 16 and 17, right? These are the sections that deal with jurisdiction. So the first is pecuniary jurisdiction. That's the value up to what the court can entertain. So let's take, for example, you are filing a case in the civil court, the Learned Civil Judge Junior Division. You can file a suit in this Learned Court of the Junior Division only if the suit is valued at up to 5 lakhs. Even if the suit is valued at 5,10,000, then you do not have pecuniary jurisdiction, right? Then you are in the wrong court. So please note these valuations before you file your suit, because again your claim will be returned. So then again you have to explain to your client why is the suit not proceeding. So pecuniary jurisdiction, please ascertain, right? So 5 lakhs is up to junior division. I may be subject to correction if the law changes. 5 to 6 lakhs is senior division, and then above 6 lakhs is unlimited jurisdiction. Now, if you see 16 and 17, let's read it together, right? Stick 16 is talking about where the subject matter is situated. So 16 is basically in essence saying that supposing the suit property that is disputed is in Gangtok, you file the suit in Gangtok. You don't file the suit in Namchi. And that's why these basic things, please remember. Now the most practical problem that will arise is, I'll ask this question to you guys who are law students, is supposing you are in a partition suit, the family has properties located in Gangtok, Jorthang, Namchi, right, Gazing. Where would you file the suit? It's a simple question. Anyone? Anyone? Try, you don't need to think. Even we make mistakes. When we go to court, we make mistakes. That's how we learn. Anyone has an idea? I'm talking about subject matter. 17. You have the right to file anywhere you want. In all these, wherever those properties are located, any one of those courts has jurisdiction. Now there's a recent case that has just come to me, a brief. I will not talk about the case number, etc. But that deceased person had properties all over India, right? Including West Bengal. But just one small property is located in Sikkim. So that entire suit has now been filed in Sikkim. But it's still good law because of section 17. That's how it works. Right now, that knowledge is up to you. You do what you with. But most of the times, for the sake of convenience, people choose the location where to file the suit. So, with regard to pecuniary jurisdiction, like I told you, 5 lakhs, 5 to 6 lakhs, and then district judge unlimited. Now, what is the law with regard to this pecuniary jurisdiction? Okay, in Sikkim, this Kharga Bahadur case of the Honorable High Court of Sikkim is a landmark case for all of you who start practice in civil suit, is because many times litigants in Sikkim cannot afford a lot of money, right? So sometimes your land will be in acres ma huncha. Acres ko tapale market value login kati huncha, crores huncha. Court fees तीनों पर्छ based on percentage. Your percentage, if you pay court fees, it goes in lakhs. Can a middle class or a poor person afford that kind of court fees? No, right? So this problem arose in Kharga Bahadur. In fact, before Kharga Bahadur was Sham Sundar Rasaili, but Kharga Bahadur clarified it further. Isma kiye baat thi bane nahi. The learned senior counsel is my dear friend's father. He argued that the plaint should be rejected, again like I said, valuation of suit. He said the market value of the property is in crores, but the valuation of the suit is only in lakhs. Therefore, there is an undervaluation of the suit. Order 7, Rule 11 ma baad ma tapale heria bhane, it talks about valuation also. Okay, that's why it's important. So this matter eventually reached the High Court, right? The High Court looked at our own laws, because if you notice, Sikkim has its own laws on court fees and court valuation. So the High Court in Kharga Bahadur, right, looked at it and said in Sikkim ko court fees rules only the word claim is there. They did not, the rules do not mandate a particular way of valuing your suit. It is up to the litigant how he values his claim, alright? And therefore, it is up to the litigant how to value his suit, and therefore you cannot value the suit based on the market value of the property. That's how the law was laid down in Kharga Bahadur. You will come across this problem all the time in civil suits when you start off because of this valuation problem. You will find seasoned lawyers when you start off your practice trying this. They may know about Kharga Bahadur, but since you are a beginner, you will file your suit around valued at 2 to 3 lakhs for a property that's worth acres. A seasoned lawyer will try to file a rejection of plaint against your case saying that the market value is different. Now it's up to you to assist the court that Kharga Bahadur applies. The court is saddled with too many cases to to do the research for you. That's the job of a lawyer, right? So please note this: valuation, suit, claim, etc. Now, before I begin on my next case that I'd argued on, please read Snehallata. Snehallata talks about jurisdictions into three types, right? But most importantly, it talks about subject matter jurisdiction. Pecuniary the boyo on the subject matter. Why it becomes important is, after this I'll go into the next case that we did, right? What does Snehallata say is, jurisdiction as to subject matter, however, is totally distinct, stands on a different footing, where the court has no jurisdiction over the subject matter of the suit by reason of any limitation imposed by statute, charter or commission. It cannot take up the cause or matter, and order passed by the court having no jurisdiction is nullity. How is this important? Anyone can tell me? B, guess. Use your creativity, then I'll tell you how it applied practically. Anybody? Forget pecuniary, forget territorial, right? Location of property. Anybody can guess how this applies? Try? Alright, okay. I'll move on to a practical thing what happened in our case. So this was called BPP versus UCO Bank, right? BPP was the landlord. Lease expired for UCO Bank. The UCO Bank was staying on lease in that property. The landlord went to UCO Bank and said, your tenure has ended. Please increase my rent. UCO Bank refused. Then he said, okay, I'm giving you almost 2 months notice. Please vacate after 2 months. They refused. Next thing you know, the landlord got annoyed. He sealed the premises. He sealed it in a fit of rage. Thereafter, the bank went to the police station. The police, since they do not adjudicate on civil disputes, they tried to act as mediators. So the bank and the landlord sat in the police station, where an agreement was drawn that the bank would vacate the premises and leave after a certain period. That was off the record, right? Now what happened eventually? The bank manager got offended. He consulted with his legal team. The legal team filed a civil suit. The legal team filed a civil suit and then obtained an injunction also against the landlord ex parte, without the landlord's presence. Now the landlord comes to us in a fit of rage again, outraged. What should I do? This is atrocious. And on top of that, he was slightly, impatient person. So he wanted relief immediately. He didn't want to undergo a long trial. Then me and my partner, we were like, okay, let's do a long suit on name. I don't see any other way. Then one day, while driving, a thought came across to me. The bank was in occupation of the premises to run a commercial enterprise, right? Then I did some research. What led me, was to a conclusion that the suit was filed in the wrong court, not because it was not a civil court, because only a commercial court could adjudicate a commercial dispute. So now what do we have a situation? The civil judge has now entertained a suit where the judge did not have jurisdiction to entertain a suit. Right? So what did we say? We said this court does not have jurisdiction on the subject matter. Now see, this is why Snehallata Goel was important, right? Because if the court had no jurisdiction on the subject matter and only a commercial court had jurisdiction, that means any order, if you follow Supreme Court, was void ab initio. That means the injunction was also void ab initio, or I should say stay. informally. What was our next step? Our next step was, now if there was no jurisdiction, then the court had to return the plaint. It was filed in the wrong forum. Right? Now, the other side, knowing that fatal mistake, asked for a return of the plaint. I mean withdrawal of suit. Right? I'll go to the distinction between return of plaint and withdrawal of suit much later. But to hide that, they asked for withdrawal of suit. But the court was very firm. The court said, nothing doing, I am returning the plaint and disposing this case. So within, I think, 1 or 2 months, this case was disposed on the issue of subject matter. That's why I kept telling you from the very beginning, please look at your subject matter, territorial jurisdiction and pecuniary jurisdiction. Now let's go to another important thing in your plaint, is your affidavit. Right? Tapaile dekhcha plaint ma, there's always an affidavit attached. That is now found in Order 6, Rule 15. Now if it's a commercial suit, it's Order 6, Rule 15A. Everybody just cursorily looks at it. They say, yo, bani raksa, save as otherwise, this, affidavit haldium na bani. Right? 15A is for commercial suit. This is where the problem arises. When you file a commercial suit, there's a fixed format for filing that affidavit. Fixed format. If somebody has CPC, please Google it. In fact, it tells you in detail how it is to be written also. Now here you have a problem. Again, where you filed a commercial suit, but in haste you filed it as a normal affidavit instead of a affidavit as per 15A. This is another problem we faced. So over here, I had filed a commercial suit. The affidavit in my haste, see, I make mistakes. That's why I'm telling you, all of us make mistakes. I filed it in a normal affidavit format under Order 6, Rule 15. The suit was a commercial suit. It had been going on for quite a few years. So the affidavit was not as per Order 6, Rule 15A. Thankfully, the other side never discovered this. I discovered it on my own. Now the question was, what happens if that affidavit was not as per Order 6, Rule 15A? Anybody? Guess? Try. I've made a mistake here. What would you have done? Try. You guys have to be confident to speak. The whole point of litigation is speaking on it. Guess. What do you think happens? I have not filed an affidavit as per Order 6, Rule 15A. Any guesses? The court's view. Is it readable? Not at all, unfortunately. Let me try to reduce the size. Is it readable now? Let me try and zoom in, okay? Is it now readable? Now I think so see, this what the court says is, when the law provides that an affidavit has to be filed in a particular manner, the party has no choice but to comply with it. By the present application, the plaintiff intends to bring his plaint in conformity with the law. Under such circumstances, it would not be proper to prevent the plaintiff from doing so on certain technical grounds. As the case has not come to the stage of first case management hearing, and since the defendant will not be prejudiced, I find that application should be allowed. By doing so, the pleadings in the present commercial suit will be aligned to the provisions of Order 6, Rule 15A. This is what the Honorable Bombay High Court in the case of Higher Telecom has also propounded. So, this was what eventually happened. Right? So, how did we argue this? I did my research. That's why that time yesterday moot court was so important. It led me to multiple judgments where, even strangely enough, the Delhi High Court had allowed this affidavit to be changed even conclusion of final hearings. Final hearing conclude, Goyerapani, they allowed the party to change their affidavit. So the takeaway here is this affidavit's compliance is directly not mandatory. It is not fatal to your case. Another judgment I found of another high court, maybe higher telecom, said that in that case the defendant filed an application to reject your case, saying it's not in conformity with Order 6 Rule 15 here. There also the court allowed the affidavit to be changed and said you proceed. Why is this important? You will come into practice, you will face this problem. You will have a seasoned lawyer come and say, my lords, Order 6 Rule 15A affidavit is not in compliance. Therefore, this is barred by law because she's not followed the mandate of law. You look at it, you'll panic, right? And say, oh my God, what do I do now? Do not lose your panic. Go home, research, utilize these judgments and say it's not mandatory, it's only directory. Now, Order 7 Rule 11. Order 7 Rule 11 is the most used application. Many times people file it as a strategy, see, practically speaking, right? Many times Order 7 Rule 11 is filed very often to reject the case at the threshold. Maybe if there's a strong ground. But also many lawyers, seasoned lawyers, what I've noticed they do is, they file an Order 7 Rule 11 to take some time to file that written statement. Because once that plaint is filed and as a defendant you are on board, you will get a very short amount of time to file your written statement. And sometimes the plaints are so vast that you do not get time to file. Right? Yeah, draft. You'll have other cases to do. So what do? They file this Order 7 Rule 11 merely as a delaying tactic to have a hearing on this and buy a few weeks. So do not panic if an Order 7 Rule 11 is filed. Look at it. If you feel your case does not fall under any of these categories, then you proceed to argue this Order 7 Rule 11. But now let's look at Order 7 Rule 11, also what its main ingredients are, right? So it says the Order 7 Rule 11 will be, your plaint will be rejected if it does not disclose a cause of action or where the relief claimed is undervalued. And on being required the court to correct the valuation by the court, you fail to do so. And the last one, most important, it is barred by law, right? Your beats, it happens all the time. That's why that time I told you guys about Kharga Bahadur valuation. A seasoned lawyer will come to court and say you've undervalued your suit. During your argument, please rely on Kharga Bahadur or Sham Sundar Rasaili to say that valuation is as per your subjective interpretation. They will file it under Order 7 Rule 11B. Now let's go to the last one, the most important. Barred by law. Most important over here is this, because most of the time this is the main ground most people take. For example, they'll say your suit is barred by limitation. See? Now what happens when they say your suit is barred by limitation? These points please remember, please remember. That's why when I told you, when you make your list of dates, when you make your plaint, remember your limitation. Say, take for example, encroachment of property or anything. Say, just for example, any case where your limitation period is 3 years. When you draft that plaint, that date, if you accidentally show it as more than 3 years, your plaint will be rejected on the very first day itself, because on your plaint you admitted that it's beyond the limitation period, right? So there will be also instances where the encroachment may have happened 3 years or 4 years or some years ago, but your date of knowledge was somewhere else. Maybe less than 6 months. Now what has that led to? That has led to a disputed fact. It's not a clear case of limitation. When there's a disputed fact, then again the Order 7 Rule 11 will not apply. Please remember this. These are technical errors that are made that will lead to a very contentious hearing or to a rejection of your plaint. Right? Now, you order 7 Rule 11 hearing on the Hiri. Sometimes a seasoned lawyer will rely on his written statement or your own evidence or his evidence, and sometimes the court is so overburdened it may not note that and say that this evidence shows that this suit knowledge was there from before only. What do? The law is clear. Only the plaint has to be read. Only the plaint. You deal with that when the time comes in final hearing. You consider that evidence at the time of final hearing. But under Order 7 Rule 11, only if you made a fatal error of talking about your date of knowledge beyond the limitation period, that's the only time when your plaint is actually supposed to be rejected. Please remember this, because the court sometimes, when you do a trial in the magistrate's court, sometimes these mistakes of interpretation happen. Judges are overburdened. They will not be able to help you all the time. They expect the lawyers to come well prepared, right? So if you feel that there's a disputed question of fact that needs to be ascertained through leading evidence, taking witnesses, you have to be very clear to the court that this is a disputed question of fact. This cannot be decided for under Order 7 Rule 11 for rejection of plaint. Now, barred by law. Another example that I did. That was on limitation I talked about. This was A versus MS Simplex. I filed a commercial suit here. Commercial suit Commercial Courts Act mandates under 12A compulsory pre-institution mediation at a specified location. Alright. So here what had happened was, Tetibela, the previous council had gone to Lok Adalat. They did not go to the pre-institution mediation center like the court, the act directed. Then the case came to me, I filed it, 12A. The other side, the senior counsel, during arguments, something completely different argument was going on. The senior counsel added that as a finishing touch slightly, because that happens. You have to be aware of your case, because one day you'll be arguing, you'll go to court prepared to argue on one topic, but if the opposite side sees there's a chance of getting your suit rejected on something else, they will suddenly put it forward. That's why you have to research before. The senior counsel, while arguing the other point, completely different point, quietly slides in this point as a last line to the judge. Your Honor, 12A is not complied with. 12A is mandatory, it's written in the code. Orders reserved. I never expected 12A to be raised. Date of order, the judge comes. She says, I'm rejecting your case because of 12A non-compliance. That's how things work in litigation. Things change on the spot. We had done another hearing. I get a shocking news that, okay, I'm rejecting your plaint. What did we do? We said, we had researched it beforehand, right? We just had not argued that point because that was never the bone of contention at that point. But we had researched it. That's why I'm saying, please keep on researching, adding it to that case file which you're doing. We said, there are conflicting judgments of 12A. We said, even if 12A is mandatory, the judgment of partial automation in Supreme Court was applying prospectively. That means that mandatory nature would only apply from the date the judgment would pass. Whereas our suit was filed before the judgment. And therefore we said plaint cannot be rejected. The court agreed. Strangely enough, the court smiled also, then said, okay, then I'll have to rewrite the order. So the order was again paused. The judge went back to the chamber and the order was pronounced the next day. So, things happen on the spot. We were arguing something else, completely different. That argument was sneaked in as a last resort. Fortunately, I had already prepared for that. Let's listen to the court's reasoning now. Can you guys see that? I'll read it out. With regard to the argument under 12A regarding pre-institution, mediation and settlement, it has been observed that the latest judgment of the Honorable Supreme Court in partial automation, we declare that 12A is mandatory and hold that any suit instituted violating the mandate of 12A must be visited with the rejection of plaint under Order 7 Rule 11. This power can be exercised even suo motu by the court as explained earlier in the judgment. We however make this declaration effective from 20th August 2022 so that concerned stakeholders become sufficiently involved. In view of the consideration made above and considering the latest judgment cited in the paragraph, it is deemed that the defendants are not entitled to file a written statement and are plain stayed. So that was the main thing over here, right? I was arguing that they should not be permitted to file the written statement. While arguing that, they snuck in this argument. Thankfully, I had this judgment, I'd read it from front to back and I knew how to distinguish it. Had I not done that, I would be in a fix. My case would have been rejected and I would be in a very embarrassing position. Now, you've understood how the main points you need to ensure in your plaint. You've understood what are the main things that consist in a plaint. Now let's take for example, you file your plaint. Your documents have been filed, right? But now you come across other documents that are relevant to prove your case. That's the whole purpose of Order 7 Rule 14. CPC is made to ensure things proceed in a, logical and clear manner. So now say for example, Tapayar ko title suit solve land encroachment ko. You obtain some document, a joint inspection report or something showing that which makes your case better. You've obtained it recently. Plaint is already filed, written statements already filed. Order 7 Rule 14 ko application annos. Right? But Order 7 Rule 14 ko your application say what it says is a document which ought to be produced in court by the plaintiff when the plaint is presented or to be entered in the list to be added or annexed to the plaint but is not produced or entered accordingly shall not without the leave of the court be received in evidence on his behalf at the hearing of the suit. Again the word leave. So application has to be filed, the other side will file the reply, hearing huncha tyहाँदेखि मात्र तपाईको that document becomes part of your evidence. Alright? So here also this happened long time back. Suit was for encroachment of property. Amro pleadings were already filed. Suit was a 2014 case. It kept on fighting, went to High Court, then it came back in 2020. The defense was of the view that this is a 2014 case, 2020 bhayo. It should not be permitted to be allowed, right? And we said that please allow these documents. The court's reasoning is here. Oh my God, all these things are completely not visible. Let me see if I can do something. Now is it visible? Is it visible now? Okay, so see the court says, learned advocates for the plaintiff submit that today is the date fixed for hearing of the application under 2610A and Order 7 Rule 14. The plaintiffs have filed two applications which they wish to with respect to the application under Order 7 Rule 14. The advocate submits that the same is procedural law and should be construed in a liberal manner. Further issues have not been fixed in this case, that the documents were not in possession of the plaintiffs earlier and they have found the documents only after RTI. Learned advocate also submits judgments in support of his arguments and therefore the court goes to this reasoning. It is seen from the records that the documents in question have been procured by the plaintiffs through RTI. It is further seen that the documents prima facie relevant to the dispute arising in the suit. It is further seen that the case is at the stage where issues are yet to be finalized. In such circumstances, the petition is allowed. Now see, what you can see from the Honorable Judge's reasoning is, you have to show to the court why your documents are relevant. Number one. Number two, your application issues frame garnu agadi नै तपाईले गर्नुपर्छ. Issues, what does issue framing means is, त्यो civil suit को एउटा stage आउँछ. There's a stage where after you file the plaint, the written statement is filed, other miscellaneous applications happen, etc. there will come a stage where the court says, let's frame issues. What is the main dispute about, Banera? So Order 7 Rule 14 ko, you cannot file it at any time you please. You have to file it before issues are framed. Alright? So please consider when you're drafting this application, you mention why the documents are relevant, why it was produced late, right? And you mention that it is before framing of issues. Now let's go to the next one. Any questions thus far? Guys, any question? Alright. So, res judicata. Everybody knows res judicata. I think that's one of the most used topics in court, in law college, right? What do you guys think of res judicata? Then I'll tell you a practical case that we did. Very interesting. Very next slide. Anybody? Try. What is res judicata?
So barring of the same.
Yeah, speak.
So barring of the same suit to be filed again in another court or any other jurisdiction.
Correct. Absolutely correct. Right? But now this is what the law says. But reality, things are always muddy, always unclear. Something else is happening. Something else. Even if you read the provision, it says, no court shall try any suit or issue in which the matter directly and substantially in issue has not been directly and substantially in issue. Former suit has been decided finally. Long sentences. Now what happened in this case? This was a case that I argued in High Court. Alright? So see the facts. Very complicated case. The file was this big. Disposed all the way up to Supreme Court. Reinstituted. See the facts. Plaintiff files a suit against defendant 5 saying that this person is building in my plot. Right? Plaintiff says my plot is 2,260 square feet. Unfortunately, plaintiff loses the case. Court says that construction is not in his plot, it's in an adjoining plot. And the court says your plot is not 2,260 feet, it is only 950 square feet. He fights that case, goes to the district judge, he loses there. He goes to the Supreme Court, he loses there. Comes back, refiles the case. Same parties. What did you say that time? Tell me those ingredients, I'll just tell you why, how it applies. Same parties, same subject matter, materially and substantially decided. Second suit, same parties, more or less same property, already decided all the way to Supreme Court. But the main thing was this D5 got overconfident, started expanding his building. Plaintiff files the suit. Defendant 5, senior counsel again. Senior counsels, the best way to learn CPC is to contest a case against senior counsels. They'll bring in such complex applications that you're forced to learn and adapt. He files the suit again, application for rejection of plaint, Order 7, Rule 11. He loses that. Goes to High Court. Now here the case comes to me. I've come recently from Delhi. Okay. First civil suit directly in High Court. Case is being led by a senior counsel. Suddenly the judge says, no, you tell me what this case is about. I'm in a fix. I was not supposed to be the lead counsel on that day. But fate has its own, chart. I am there sitting nicely. The judge says, you tell me what this case is about. Fortunately, I had read this file from top to bottom, this entire file. I had stayed in my house, did not come out of my room for a week. The worst part was this plaint was unreadable. poorly drafted. So no one, the judge also was not having a clue of what the case is about, right? So what I did was, I made my list of dates. Here again, practical application. Made my list of dates, went through all the documents in the plaint and the written statement that was attached by all parties, made the list of dates, started reading it. I understood the dispute completely. So when the judge said, tell me what this case is about, I told her two things. I said, res judicata does not apply because even if the subject matter was same, parties were same, it's a fresh cause of action. And that's why you need to read judgments on res judicata. There are exceptions carved out to res judicata. On the face of it, it looks like a case barred by law. Clear, it looks like that. But I submitted to the Honorable Judge that time that once those fresh constructions took place, there was a re-encroachment of the same property, of the same parties, same dispute, so it's not barred by res judicata. Alright, so again here, let me just try to zoom it in for you guys. This was the Honorable High Court's view. Can't be zoomed also. Okay, stays at 100%. Okay, yeah. Can you read it now? Is it readable now? On due consideration of the rival stands, it thus emerges that the dispute and fresh title suit pertains to the alleged encroachment made by the petitioner allegedly on plot 882 and is not confined to admitted encroachment of plot 881. Although I have to remark here that the nebulous drafting on the part of the plaintiffs has confounded the matter in view of the flagged circumstances as correctly held by the trial court, it is clear that neither suit is barred by res judicata nor is it barred by order 2, rule 2. Section 11 of the CPC inter alia provides that no court shall try any suit or issue in which the matter directly and substantially in issue has been directly and substantially in issue in the former suit between the parties or between parties under whom they claim to be litigating in a court competent to try the subsequent suit or the suit in which such issue has been subsequently raised and heard. So basically the court eventually comes to a finding that, I submitted. These fresh encroachments are a new cause of action, therefore it's not barred by res judicata. And therefore the court dismisses the application for rejection of plaint and then says that the trial needs to continue. Right? Anyway, so I've just been informed that there's a tea break from 11:30 to 11:45. We will continue at 11:45 sharp. Alright? Because there's still a lot more of CPC I need to cover with you guys. And then I need to quickly go through some provisions of CRPC and then a brief bit about what you guys should do once you join the bar. One second.
Thank you, learned resource person. Now we will take a quick 15 minutes tea break and then, I request everyone to kindly be at the banquet hall at tea break and we will resume our deliberation at 11:45. I request everyone to return promptly. Thank you.
Judices. Somebody fast, we don't have time. Look, I am on slide 32, there's 64 slides here, then there's 25 slides in CRPC. I have to move fast. Fast, guys. Sub judice. What is it? Try, yeah? No one? Anyways. So this sub judice finds its place under section 10 of CPC for a very particular reason. Say you have suit A is being decided, then the plaintiff again files suit B against the party. Right? So section 10 says that till suit A is decided, the main issue in suit A is decided, suit B has to be stayed. So in practicality, supposing you have filed an eviction suit as landlord against the tenant, if you file a subsequent suit on a very same issue, on the issue of eviction only, for all intents and purposes, suit B will be stayed by an application made by the defendant under section 10. It's not stayed suo motu. Okay? So that is your defense if you are the defense that you file a section 10 application if the question matter is substantially and directly in issue. Right? The word over here is no court shall proceed with the trial of any suit in which the matter in issue is also directly and substantially in issue in previously instituted suit. Res judicata, it was disposed the first suit. Here is an issue where the first suit has not been disposed. So that is what section 10 was about. Let me now go to what happens. This is an ongoing case. Recently we won the court order in our favor. Over here, we had filed a suit to say that our client, B, was the daughter of A. Thereafter, we won that case. The party went on appeal against that judgment, right? Secondly, we filed a second suit saying that I am the daughter of B and I need a share in those properties. The other side filed an application under section 10, okay, saying that since the judgment is under appeal in the first suit, kindly stay the second suit because the finding of whether B is the daughter of A is still being adjudicated upon. And since if you go back to section 10, matter is directly and substantially in issue. Factually the same the boya hai na, right? Same boya nahi. I mean, it's a very difficult proposition that we are in now. Daughter is still being decided. You're filing a second suit saying, you're the daughter. It's the same issue. The daughter has to be confirmed. Banera section 10 application boya. What do you guys think should happen here? Ashmita? No, we are talking about section 10. Stay of suit, subsequent suit. The question, let me go to the facts, okay? Yeah. First suit filed claiming to be the daughter of A. I won. I've gone on appeal. Second suit filed, the defendant has gone on appeal. Now after being the daughter, I've gone on a second suit asking for share in the property. The second party now files the defendant now files a section 10 application asking for stay of suit in the second suit saying that the daughter still has to be decided, it's under appeal. Now go to section 10 core wording. It's a very cryptic meaning. Matter is directly and substantially in issue. What do you think? Try. This kind of complex stuff only happens in civil suit. When you read the provision, it looks like, lagne to raisa, but everybody thinks lagsa hai na, yo. What do you guys think? Section 10 applies. Because the defendant is saying, daughter is still being decided. How can you now claim daughter? That's the main issue in dispute in the second suit also. What do you guys think? Laksa?
The new parties are involved in second suit.
Yes. This section 10, that's the problem we are now facing. Same parties, first suit, A wins, saying she's the daughter. Defendant goes and appeals. Second suit, now she files saying, give me a share of the property. But now the defendant is saying, since the first suit, the main issue is the daughter or not, second suit is barred under section 10. You cannot adjudicate this right now, it has to be stated. What do you think? And section 10 is saying matter is directly and substantially in issue. Teti mate bani rakse section 10 ma. Ke lagse tapa? Try. This is still a churning case. Maybe we won one round, who knows? The High Court may go another round. Supreme Court may go another round. What do you think? Feel free. This is not a set law as of now in this case. Stay hunu parsa? Ki pardena? How many of you say stay hunu parsa? Hands up. So everybody says stay hunu hundena? Great interpretation of law. So what did we contend here? Right? We said for this section 10 to apply, the key ingredients are the whole matter has to be same. The first court should also be competent to grant that relief. The cause of action has to be same, the relief has to be same. That's how we distinguished it. Section 10 ko provision ma to yo lekhe gaye chaina, right? Why did we come to this is when we did our research, Supreme Court ko judgment called Aspi Jain in 2013 clarified this. Aspi Jain ma kiye baat thiyo, landlord tenant dispute happened, rent koi issue ma, both High Court and Trial Court kept saying Section 10, Section 10, Section 10. It goes to Supreme Court, the Supreme Court says, no, fine, parties are same. Property is also same. Cause of action is different. Everything has to be same, the Supreme Court says. Aspi Jain's ratios here, see? For an application of Section 10, it is further required that the court in which the previous suit is pending is competent to grant relief. First ingredient you note, the basic purpose and underlying object of Section 10 is to prevent the courts of concurrent jurisdiction from simultaneously entertaining an adjudication upon two parallel litigations in respect of same cause of action, same subject matter and same relief. It further goes on to say, for Section 10 to apply, the whole of the subject matter should be identical. Please note this down because they will use this against you eventually. Somebody will just rely on Section 10 co provision, show it to the court and say stay this suit. It is only you who can assist the court and say that Section 10 co reasoning is clarified in 2013 by Aspi Jain and these are the key ingredients that should match. Therefore, Section 10 will not apply. Alright. Now Order 8 Rule 1. That's where your written statement comes. These are all the key ingredients that you did as a plaintiff. Now let's go as to defendant. Order 8 Rule 1 is talking about your requirement of filing a WS as a defendant. Now please note there are two provisos, provided that one. Let's say proviso bansa. One proviso says that the written statement has to be filed within 30 days and extendable up to 90 days. The second proviso again adds a different wording. 120 days from the date of service of summons, the defendant shall forfeit the right to file the written statement and the court shall not allow the written statement to be taken on record. This is where the distinction again happens. If you're in a civil suit and not a commercial suit, which is actually a civil suit but for specific kind of cases, you cannot file a WS beyond 120 days. Ashmita, we were discussing that time. So that delaying tactic in commercial suit is not advisable. So 120 days ko baad you are barred completely. But in a civil suit, that is not a commercial suit, you can file beyond 90 days also. Several instances have happened. Many times courts have also said this. One of the main judgments being Bharat Kalra, right? So in Bharat Kalra, the suit, the written statement was filed after 193 days. The High Court and Trial Court also did not allow it to be filed. Bharat Kalra relied on Kailash versus Nanku and said that first proviso that we talked about in CPC, Order 8 Rule 1, for civil suits is not mandatory, it is directory. So therefore, subject to payment of cost, you can file your civil suit, your written statement. Okay? But please note, commercial suit do not extend 120 days, otherwise you're in a very bad position. Now, here was a case where the written statement was filed beyond 120 days that we argued. Unfortunately, it's not clear. But here the court eventually prevented them from filing written statements. So it's not like something that is only written in a piece of a bare act. This has actually happened in Gangtok. Order 8, Rule 3 to 5. You learnt that in your plaint you need to mention your material facts and this cause of action, etc. and all. Most important thing as defense, please note, your denial has to be specific. You cannot be evasive. Many times lawyers will write evasive denials, and a smart plaintiff lawyer will use that against you. Because Order 8, Rule 3 to 5 are very clear, your denial should not be vague, it should be specific. You cannot say it is just denied that. Practical example. We allege that B was not the son of A, and his denial was as follows. Please see. These are mostly matters of record and shall be referred to at the time without admitting anything contrary to or inconsistent with the record. Do you think this is a specific denial? Obviously not. Therefore, if such a denial comes, and as a plaintiff you see this denial, Supreme Court is clear. Jaspal Kaur Chima. Anything you do not specifically deny is deemed as admission. And also please note, an admission that you make in your written statement is almost one of the highest amounts of evidence. It's not like a document that you had admitted. Civil suit gardakheri, you may have a document signed by the other side saying, "Oh, moile paisa lageko." That's just admission. That is just evidentiary admission. So it's a lower threshold. So a written statement, yes, I took money, or while arguing, yes, I took money, that is a very high admission. It is treated as the best form of evidence, and you do not need to prove further. So that's why please note, when you write your written statement, don't be in a rush and just write it is denied that, it is denied that. Be very specific. Now, Order 11, why I am relying on is, Abu Tabe trial gardesa, right? Many times when I was a law student also, this question used to plague my mind. You guys know evidence is only admissible if it is an original document or a certified copy. Yes? Now, you will have a problem where you are relying on a photocopy of a document which you know the other party possesses. You are now faced with a problem that I need to use this as evidence. What do I do? Right? Evidence hai boy nani. That's where Order 11 comes in. Order 11 is basically, American people also use it, they call it discovery. Order 11 must say, what do is you file an application under Order 11, 12 and 14, where you tell the court that this document, what its relevance is and who possesses it. After the court ascertains that, the court directs the other party to produce it. Now here's the practical problem. India is a place where everybody is not very honest. Most of the time, the go-to answer will be, your document harayo. Harayo paina. Now what do you think will happen? You are again back to a photocopy document. How will you use that as evidence? That's why you read Order 11 with Section 65 of the Evidence Act. What does Section 65 of the Evidence Act say? Certified already evidence photocopy. If a document is lost, then it can be adduced as secondary evidence. There, you have your document now. Several instances where I've done this, it's a routine thing I think for most lawyers that they file this Order 11 and then the department or the other party says it's lost, and then you move a Section 65 application saying please allow this to be marked as evidence. So when your document is admissible, the court will mark it as an exhibit. If the court thinks that it's not admissible, it will mark it as DOC, doc. And your entire civil suit is making sure that your documents are admissible. So, here just though we were relying on a sale deed executed by A in favor of B. We had only adduced a photocopy which was not admissible. We filed an Order 11, Rule 12. The other side objected to it. And the court, noting this judgment of Supreme Court, what does Supreme Court say? This is the only case by Supreme Court that talks about Order 11. It is your go-to judgment. It says that documents sought to be discovered need not be admissible in evidence in the inquiry or proceedings. It is sufficient if the documents would be relevant for the purpose of throwing light on the matter in controversy. Every document which will throw any light on the case is a document relating to a matter in dispute in the proceedings, though it might not be admissible in evidence. We think that the documents which were sought for throw a light and therefore it's allowed. ML Sethi Gardakiri, you can call for these documents to be produced. They will most probably in the trial say Paina. If it's a genuinely honest lawyer or a defendant, they will be fair with you and produce the original. Sorry, this is Order 13, not Order 10. So Order 13, now you've finished your filing of WS if you're the defendant, plaint has been filed. Now the next stage that comes is Order 13. Okay? Order 13, what the court requires you to do is produce all the documents that you have, the originals, with a list of documents. Those documents then are submitted to the court before the actual trial begins, framing of issues, etc. That is a very important step in the trial. Now, what if one of the documents you are using, there's another suit going on and that document is there in that suit? What will you do? Order 11 the government socket. Order 11 you ask only against another party to the suit. The document is now stuck in another court being used somewhere else. You cannot lead photocopies as evidence. That's the whole purpose of Order 13 Core, this provision. Order 13 Rule 10. You can call for these records. You file an application under Order 13 Rule 10 saying that these documents are relevant for the matter to be decided and it is in this particular court. I could not obtain certified copies, etc. You have to show that you made an effort to get it. And then the court will entertain it and allow that document to be produced. Alright. So this is the judgment of the Supreme Court, Lakshmi versus Chinnam Lal, where it says that if bringing on record a document is essential for proving the case by a party, ordinarily the same should not be refused. The court's duty being so to find out the truth, the procedural mechanics is necessary to arrive at a just decision must be encouraged. We are not unmindful of the fact that the court in the said process would not encourage any fishing inquiry. It would also not assist the party in procuring a document which he who should have himself filed. So you use Order 13 to get a document that is stuck in another court. Yes, of course. Then that's your secondary evidence. But I'll give you an example, okay? Like subsequent suit, a whole treasure trove of documents are required. It's better you call the original, because what did we learn in Evidence Act? Primary and secondary. Certified copy is? You will have a shrewd defendant say, hey, you're the certified one. It's secondary evidence. Where's the originals? Either you, if you file this, you tell them, okay, give an undertaking that it's secondary. Hey, you will not object to it being secondary. Marking time, this happens practically. So it's better for abundant precaution, you file the application, let him object that he can bring certified copies. At least you have on record that you made the effort and he objected, no? Baad mein it should not be like a certified copies or secondary evidence or primary original ka lena wala, right? त्यो त तपाईको अन्त इलेक्ट्रोनिक एभिडेन्स लागिहाल्यो B. Only problem is, no, now with this BSA, it's become even more complicated. There's a separate kind of certificate which tells you to add the hash values, all that. It's quite complicated now. If you see, Anwar Bhanne case, there are 2-3 things that Anwar case talks about. First is you can file that certificate even at the final stage. Anytime you can file it. Secondly, it says that if you've produced the screenshot from your mobile phone, if that original electronic device is handed over to the court, you do not need a certificate. It's only when you're printing out from somewhere else and it assumes the nature of a secondary evidence, then you need to get a certificate issued by the person in charge of that device. Tapeko screenshot, put the phone, give it. Unworked case. Right?
But it is admissible, right?
Of course. Phone aldino na. Certificate पण चाहिए. Alright. So you filed but that is the truth. I know it's very rare that you see because people for precaution just file the certificate, but that is the law actually. Because that happened, I'll go to that also. I think it is there in one of the cases that we did, use evidence. If not also, I'll still discuss with you guys. Framing of issues. So you filed your plain written statement, all this has happened, you've produced your documents, you've got your documents from the other court, everything is ready. Now the court will proceed to frame the issues. Framing of issues is basically the court will now take list of suggestive issues from you guys, from both plaintiff and defendant. The court is then supposed to go into an inquiry by reading your pleadings and seeing what is the dispute and frame issues, whether the suit is maintainable, whether it's entitled to, based on the dispute, right? That's why that time, remember in Order 6, Rule 1, I said, plead all material facts. Now this is where again technicality comes. Ashmita, you may be interested. Sometimes the parties will try to frame issues where they have not pleaded also. That's where you need to be alert. Pleaded, how can issues be framed? And the court is overburdened, they will not know. They'll say, oh, you're the disputed, frame. Last month, suddenly you discover pleading is the written statement pleading is. So that time you have to be alert. If the issues are being framed, make sure that fellow who's suggesting the issue has actually written it, pleaded it somewhere. If not, he's pulling a fast move. So here again the same case, Shivaji. Court cannot look into issues where pleading is not made. And now what if, say for example, issues already framed. I did not make a slide for that, I'm sorry, but now it came to my head. That is an important point. Issue frame boyare. Pleading is henare. What do you do? The provision is there only. Order 14 Rule 5 banzani. The court can at any stage strike out that issue. So you feel that fellow's taken a fast one. You file an application saying this issue was framed erroneously because this pleading was not there and it was misled. And the court will delete that issue. Or the court can even add an issue. Now, main points that the court does during framing of issues is, number one, we do not decide what the issues should be. We can only suggest. The court is the one that will frame the issues. And it is basically a crystallization of what the main assertions and denial are. The court is expected to go through your pleadings in a perfect world, not in reality. A court is dealing with hundreds of cases, right? They will not have time to read your bulky, plain and written statement for page by page and film. That is why you guys need to be aware of your case. List of dates again important. And court cannot decide on issues not pleaded. Okay. Now, once your Order 10, all this is done, issues is framed. Next, the court will ask you is, please provide your list of witnesses. Your list of witnesses are basically witnesses who will prove your case, who will appear in support of your case, number one, but also civil suit ma, private document ma, you have to prove your document. Tapale original halera hundena. Government document ho bane, there's a slightly different train of thought amongst our Honorable High Court. Some say there was a split verdict, in fact, in Osti Posco case ma nahi. Government document certified copies, author has to come and prove bane, ota benchle, or kule doesn't have to be proved, it's deemed to be proved bane. So let's leave aside government documents at the moment. Let's look at only in your private case, private documents. So when you provide your list of witnesses, make sure to add witnesses who will come and prove your documents. You will say, yes, I signed this. Then that part is marked. Then you'll have to say, did you attest to these contents that were made? That also has to be there. You cannot just file a document and expect the court to look at the document as evidence. The court will not attach value to that. Probative value ones. See, one thing you need to know about, since CPC nets all this, we'll go to Evidence Act also. The court looks at admissibility and thereafter probative value ones. In a civil suit, your document gets marked as an exhibit, original boyer. But if you do not bring that witness, or the witness does not clearly say, yes, I wrote this and this, that value of that evidence becomes low. The probative value becomes low. And in a civil case, if the probative value of the document is low, then it is not considered much. After that your cross-examination, etc. takes place, then the Honorable Court passes judgment. So that is in short the entire series of events that takes place from the time you file your plaint to the pronouncement of judgment. Now, there are some certain other provisions that are important during your trial, okay? Now you've understood till judgment what happens. First being is Order 23, Rule 3. So sometimes kya huncha? Plaintiff files a case, defendant comes, both parties mediation ma milcha, right? They'll say, let's not continue this case, let's settle it. So then what you do is you file an application under Order 23, Rule 3 for compromise of suit. With that, you sign your agreement and file it before the Honorable Court. The court will then take note of that and will pass a judgment and decree based on that. The reason being why that is a good way of doing things is later on, if there is some vacillation on the terms of the agreement, that assumes the nature of a decree only. It's binding. Now, injunction. Order 39. Right? Injunction is also one of the most used applications in civil suits. I think all of you have read it in law school. I mean, Ashmita and all also, Order 39 is now on the back of your fingertips. But I will now go to a very interesting case that happened just a few weeks or last month on injunction only that we argued in High Court, right? So, these are, according to Order 39, they say that the property in dispute, there is a danger of it being wasted, etc. These are the provisions, statutory provisions. You'll read CPC, you'll understand. But usually the three key takeaways the court looks at is prima facie case, balance of convenience, and the damage not being able to be compensated to the person applying it. Those are the three key takeaways. But what happened was even more interesting in our case. Here, that time I told you the NHI DCL, remember I told you I got a stay, we got a stay, right? So court granted a stay. They said the money should not be released and the money should be parked in a bank till the disposal of the suit. The learned senior counsel went to High Court, appealed against that injunction order under an FAO. His key contention was that order of the court when granting injunction saying that the money not be released, it be parked in a bank somewhere till disposal of the suit went beyond the provisions of Order 39. Now what did the Honorable High Court say? Is this readable? I'll be telling you. So Honorable High Court, listen to the reasoning, beautifully written. Their provision gives power to the court to grant temporary injunction and pass necessary orders when any property in dispute in a suit is in danger of being wasted, damaged or alienated by any party to the suit or wrongfully sold in execution of decree, or when the defendant threatens to dispossess the plaintiff or otherwise cause injury to the plaintiff in relation to any property in dispute in the suit. The power is granted to the court to restrain such act or make such other order for the purpose of staying and preventing the wasting, damaging, alienation, sale, removal or disposition of the property or dispossession of the plaintiff or otherwise causing injury to the plaintiff in relation to any property in dispute in the suit as the court thinks fit until the disposal of the suit until further orders. So because of that interpretation, the court upheld the order of the Honorable District Judge and said no. You cannot have this kind of literal interpretation to Order 39 and upheld the stay order of the trial court. Now let's go to commissions. Alright. Why is commission important? Encroachment suits. You say he is encroaching, he says he is not encroaching. Amin has led multiple conflicting documents. Amin says, Aina encroachment, boyo, boina. 26 Rule 9 grants the power to the Honorable Court to appoint an advocate commissioner who will go on the site, measure and verify and prepare a report. So it's not like the court is helpless and has to rely only on what you state in your pleadings. The court can also appoint on application by the party for appointment of the commissioner who will go and verify that site. Right? Now, this is what happened in our case. We lost the case in trial court. We lost it. Suit not encroachment. Why? Like I said, the Amin cleverly comes, says encroachment boina, or conflicting documents. You take two different documents, one showing the extended building, other not being shown, file on the spot look either. So on record is only the file that shows the non-extension of the building. We lost the case. We filed an appeal. During appeal, we filed this Order 26 Rule 9 application, asking for a commissioner to be appointed to verify and mark that plot and show the encroachment. 3 different senior counsels that day. I still clearly remember. 3 senior counsels, us alone, freshers. They said it's not maintainable. And a beautiful argument, I think it was Enrai sir, beautiful argument he made. He said, Commissioner also assumes the form of additional evidence. I think you guys will understand this better. They'll slowly come. Additional evidence, it has to meet the rigors of Order 41 Rule 27. Due diligence, etc. He said, your commissioner should have been filed, right, in the trial itself. Beautiful argument, that was beautiful. The only reason why I could manage to scrape out of that argument was, again, when I told you guys that time, do not plead law, only plead facts. No. That time, Enrai Sirs Jr. pleaded that law in the pleading. In his reply, he said, this is additional evidence, it has to meet this. So when the hearing started, I knew Sir is going to argue on, linking Order 26 with additional evidence. What were the consequences? I'll go to trial, then we'll go to High Court. High Court, upheavals all. Trial, this order for hearing takes place. I rely on the Honorable Supreme Court, which clearly says, if there's adjoining properties allegation of encroachment, appeal mapan, you can allow commissioner answer. Then Amro Enrai sir argues that it is an additional evidence has to meet due diligence, etc. I knew that was being argued, so then I found another judgment of the Supreme Court. And in fact, later on I discovered that Honorable Justice S.P. Wangdi has written a similar judgment. It says that additional evidence can be also permitted to be added if it removes obscurity. So I said, look, there are 2 conflicting documents issued by the Amin. There is obscurity on whether there is encroachment or not. So even if additional evidence principles are applied, it is still applicable. So thereafter, the Honorable Trial Court passes the order in our favor. It goes to the High Court. The Honorable High Court also is of the same view. It says the Commissioner can be appointed at any stage. It relies on the judgment that we had cited only, Surya Narayana, right? And dismisses their appeal against the grant of the Commissioner. Now, eventually what the Commissioner came to was a conclusion, it's an ongoing trial, but the Commissioner came to a conclusion that there was encroachment. So that's what happens. It's not like just because you lose a trial, you couldn't prove encroachment that all is lost. The battle restarts in appeal sometimes. Only if you made sure your evidence, etc. is properly adduced. Alright, now another important provision during trial you'll find is 115 of CPC. And you relate that with 227 of the Constitution. All of you law students know 226, 227. Why is 115 important? Is because earlier, before, what happened is in CPC 2002 there was an amendment. Paila kya hote, anytime you lose a miscellaneous application, you file a revision immediately. Let me go on revision. So what happened is the Parliament thought this is getting too much, trial is getting delayed. We will not allow any revision for any random miscellaneous application disposal unless it is very necessary. So 2002 what the Parliament did was they amended it. they only allowed revision to apply to cases where had your application been allowed, the suit would have ended. Take for example, plaintiff's file, you as defendant file your written statement. Then post that you file your order 7 rule 11 for rejection of plaint. Now had your rejection of plaint been admitted, then the case would have been disposed of. That is when 115 applies, right? So it was in these situations 2002 amendment was reduced. These also called Jaitley amendments, because the late Arun Jaitley was a key person in passing these amendments. So therefore 115 ko scope reduced hoya. Now what happened is problems started happening, right? It's not every time that it's a perfect situation where you can only challenge your rejection of order 7 rule 11. There'll be other instances where some miscellaneous application is not allowed, etc. Right? So then, what are you left with? The Supreme Court then realized that, okay, you have to have some leeway allowed for revision despite this change in the law. The Supreme Court thereafter in Surya Dev Rai and consequential judgment says that if you are challenging a miscellaneous application co-order which is barred by the proviso of 115, you can file a writ petition under 227. And that's why you start going under 227 or to the High Court. Alright. Now, the last few provisions important is the judgment comes out, you go on appeal. Appeal ma, when you file the appeal, sometimes you lose. Say, take for example, you're the tenant, you lose. Now the landlord is about to chuck you out because he's got the judgment in his favor. You have to file an Order 41 Rule 5 application separately before the appellate court. The reason being that if they are planning to execute that judgment, the landlord will take possession of the property. And just because you appeal does not mean you automatically get a stay of that judgment which you lost. So as a prudent lawyer, please file your Order 41 Rule 5 immediately when you file your memo of appeal. Your memo of appeal will contain the certified copy of the judgment and the impugned decree. Alright, now another important thing that happened here in Order 41 Rule 5 when we did was, like that time I told you B was declared the daughter of A. The other side went and filed an application under Order 41 Rule 5 with a prayer that you stay that judgment, stay it. We were directed to file our replies. We did a hearing. They came. They said, I'm filing this application under Order 41 Rule 5, and since this matters on the appeal and the question of whether she's a daughter yet still has to be decided, please allow this application under Order 41 Rule 5. We countered that, right, with a research that led us to a finding that you can only stay execution of the decree. You cannot stay the findings per se. So we said, first, we have not filed an execution petition. Secondly, these are findings. You cannot stay findings. So therefore, the appellate court also came to a conclusion that whether she is the daughter or not is a finding that cannot be stayed. I shall at best stay the execution. Alright. So please note these important things. Now also in CPC, few other points is Order 2 Rule 6. I'll open it here. These are provisions that you will not hear much, but it's very important that you see. Can you see this? Sometimes you are the plaintiff, A, B र C रे property encroach गर्छ. तपाईले हतारमा B र C का against मा same suit file गर्दियो, or say you are one of the counsels for B or C. Technically there are two causes of action. You have a cause of action against B and C, right? So if you are counsel for B or C, you can file an application under Order 2 Rule 6 saying that you split this trial because these are two separate causes of action. You understood? Any question? Is anyone confused about Order 2 Rule 6? Practically huncha. I'm giving you an example. Let's not look at ourselves as plaintiff, let's look at ourselves as defendant. Plaintiff has a property here, B ko न्याछ, C ko न्याछ, दुई जनाले encroach गरेको. Plaintiff filed a suit, single case against both, making both of you defendants. You guys can therefore as counsel ask for splitting of the trial. Why should you be bogged down by the other person's trial? Splitting of suits. Right? This splitting of suits also becomes relevant, like that time I told you, when there are multiple properties all over India. And that person files a suit in Gangtok. And then cleverly tries to rope in some other person in the partition suit and tries to put in some other thing here. You understood? It's called clever drafting. 10 properties all over India. One of the properties is contested for sale between a private defendant and him. But now to drag all this, he creates a partition suit. 10 properties. That poor chap also now who's contesting a separate issue comes here. What do you do as the defense counsel for that fellow? Order to Rule 6. Separate cause of action. Split the suit. Why should you be bogged down in a partition suit for cause of action where this fellow is challenging the sale deed? Separate cause of action. Then, in fact, in this case, I'm not talking about the case per se, what is going on. But in this case, there was already a case going on in West Bengal on the same issue. So what would I do next? Again, Section 10. Split the suit, stay the suit. Let this fellow try his mischief. Right? Because once the suit is split, the matter is directly and substantially same in issue as the one going on in West Bengal. So obviously the Section 10 will apply. Now another provision in CPC that's important is so basically Section 25 of the CPC Can you see this power of Supreme Court to transfer suits? You will face this problem. We face this problem. I had a lady from my village come to me where her husband had filed a restitution of conjugal rights case, Section 9 in Malda. Bichara goisa. Gunda lagara dagdi dekai na. So then what did I have to do? Then immediately what happened is I asked her, are you being paid maintenance? Maintenance pan tirek sena. So I filed the suit for maintenance in Namchi, right? Poor lady, she's got a 2-year-old daughter, maintenance pan tirek sena. Suit started in Namchi. Then the next thing I did was, I moved a transfer petition in the Honorable Supreme Court. Under 25. It's only the Supreme Court that can transfer interstate. The Honorable High Court can transfer intrastate, right? So transfer petitions, if you want shifted from Gangtok to Namchi, you file it in Honorable High Court. But interstate, only Supreme Court under 25 does this. So when we file this transfer petition, the best thing about Supreme Court is these matters are treated as urgent. Immediate listing. Immediate. First line, immediate. We got it listed. It got passed. The Honorable Judge heard the case, immediately stayed the Malda proceeding. Immediately stayed. I said it's more than 300 hours away every time. 300 kilometers away. Every time she goes, she gets threats. Ex parte, the Honorable Court stayed it. Then the next day, this husband again played mischief. He acted like he didn't get summons. So you're well aware they avoid summons. So again, he thought he'll avoid summons. But Supreme Court is not, very casual with them, not forgiving. Immediately on the next day, the Supreme Court passed an ex parte order transferring the case from Malda to Nanjing. Immediately. Now suddenly the husband wakes up, comes to Supreme Court, files an application for recall of order, right? Saying that order has to be recalled because there was violation of principles of natural justice. I was not heard only. Now, if you guys as law students do your research, every judgment of recall of order will say that if there's violation of principles of natural justice, the order has to be recalled. Here we were at a predicament, right? Because the law goes against us. The Honorable Court passed it ex parte. So then we went prepared for the hearing. Now, but that's the beauty of how much power Supreme Court has, you know. Honorable Justice Surya Kant was the presiding judge. He'll be the CJ in 25 onwards. So what he did was, he said, okay, I feel you've had a violation of principle natural justice. The case order was passed without your presence. You argue the matter. He started arguing the matter, half an hour. Then he said, okay, you argued the matter. Okay, we recall that order, but now we decide that this case will still be transferred. And then the husband says, no, please don't. Then Justice Surya Kant laughs and says, no, the weather is very pleasant in Sikkim. You go enjoy yourself there. So eventually, see, he molds his order, not formally, but looking at the need of the, circumstances. Had he followed it theoretically, I looked at it that way. I thought, abo order recall huncha, pleadings file gad bhancha, then yesto huncha, testo huncha, bhane lamo jancha, and the husband will misuse it. No. He looked at the situation, he looked at there's going to be a probability of mischief. He recalled the order during the same hearing and he disposed it off on the same hearing. Now I shall go on to a few points of CRPC also now that major portions of CPC is covered. Okay. Alright. So, first I'll go as bail because all of you freshers will start with bail only. 436, 437, 439. When bail may be taken, when things. Triple test. When you argue a bail petition, stick to the triple test. I'm not saying it's a guarantee it's going to work, but stick to these basic principles. Whether the accused is a fight, flight risk, whether the accused will tamper with evidence, whether the accused would influence witnesses. This triple test, even A.M. Singhvi talks about it. I mean, the courts have consistently said that it should be granted. But you have to remember one thing, bail is a discretionary jurisdiction. No amount of pleading, no amount of using hundreds of case law is going to give you a guarantee that you are going to get bail. It's the Honorable Court that decides whether the discretion should be exercised to grant bail. But be that as it may, when the prosecutor starts arguing, there are certain important case laws that you need to rely on because they are go-to arguments that the prosecutor will rely on. Number one being tampering of witness. Go-to. So this was already settled by the Honorable Supreme Court in P. Chidambaram, where they said that you cannot make mere averment that the petitioner will tamper with the witness. You have to show some documentary evidence or some evidence that he will tamper. Second allegation the prosecutor will make is, oh, these are grave offences, right? So there again the Honorable Supreme Court and the Delhi High Court have said the graveness of the offences is not the only thing you should consider when rejecting bail. Now these are not magical formulas that will work. The discretion is up to the court. I am only saying how you tackle a problem that arises. Now also please note, if you see 437, bail for non-bailable case, there's a provision that clearly says that when that person is accused of a serious offence with life imprisonment or death, the NBW, the bail cannot be filed in the magistrate's court. Now, practical problem that arose. Few months back, let me be very clear now since that matter has died down. Few months back, you guys heard the case in Supreme Court where the Allahabad High Court had passed some comments about the victim. It was all over the news. Victim brought it upon herself, but no one. It was a major controversy all over the news channels. So, see, I'm being very candid here. That was a case that was done by my friend. He sought my assistance. Right? And the facts of the case were completely different from what actually transpired. The facts of the case were that the victim and the fellow, they went for a night out together. They went for a night out together, then they danced the whole night in a club. Then they went back to his friend's place. She stayed the whole night. Then he dropped her off. Then God knows what happened with her boyfriend. Then they came later, many hours later, and said, you did this. Then she filed the case, and then rest is history. You guys well know about it. Now many problems arose in this case is because if you see, the problem is the new BNSS says that the FIR can be registered anywhere. Earlier, concept of zero FIR was created by the Honorable Supreme Court. The UP police misused that provision by reading it in isolation. Victim filed the FIR in UP. Offence was committed in Haryana. UP police went to Haryana, picked him up, brought him on to UP court, filed the charge sheet there, did everything there. So in essence, that entire case was actually vitiated. Right? But now when my friend comes, he files this 437, and I tell him, you cannot file this here because you're accused of a crime that is punishable with life. But you know what happens, Reza, in UP courts or some other courts? They have a procedure that is their own. So they say that even if the provision statutorily bars you from the court from entertaining it, what they do is they file this 437 in the magistrate court, automatically a rejection happens, then they go to the sessions court to get bail. Now all this was happening despite a clear Supreme Court judgment, despite the clear Supreme Court judgment saying that there is no reason to go on the 437. If you have an offence that is punishable with death, you can directly go under your 439. But see, that's the practical reality. What you study in the case law and what you see in the provisions are completely different sometimes. Right, now let's go to jurisdictions. That time we did jurisdictions in CPC 177, 178, 179. Jurisdiction plays a very important role in criminal cases also. Right, 177 says the trial will take place in the place where the offence was committed. Then 178 goes on to say, when it is uncertain whether trial was committed, and if it happened at multiple locations, the court in all those locations will have jurisdiction. And also 179 says you look at whether consequence arose. Now why am I talking about this is this case. This case is a case that was adjudicated by the Honorable High Court. No, this was not a case, but I'll tell you why we come to this case. This was a very unique case that came to us. FIR was registered in South India, alright, and then the police came and arrested him, and then the police wanted a transit remand. Problematic. Why problematic is because we were faced by a severe disability. The Honorable High Court of Sikkim, in a judgment in Savitri Devi, said that the court of remand over here will not have jurisdiction to even grant transit bail if the offence was committed somewhere else. Right? So look at this. Coming to the question of propriety of the Sessions Judge Danchi in granting bail to the accused while perusing the FIR, there can be no manner of doubt that the offence was committed in the district of Darjeeling, West Bengal under the jurisdiction of Sardar PS. It is also evident that the name of the accused finds the offence has been committed in Darjeeling, West Bengal. The FIR has been lodged in Darjeeling, West Bengal, and the accused is a resident of Darjeeling. Therefore, she was arrested in Namchi. It does not clothe the Sessions Court with jurisdiction to grant bail. Now, what was our problem? Our problem was this judgment was now, binding law. Binding law. But now that time when I told you about 177 and 178, what was it? 177 says only where the offense took place, but 178 carves out an exception, right? It says that if the offense happens in multiple places, both courts have jurisdiction. So we went before the magistrate's court. We said, look at this FIR, look at the contents. The allegation is like money was transacted from South India to Sikkim, to an account in Sikkim, for an alleged project in Sikkim. So we fall under 178 and not 177. And then in fact we relied on Sabitri Rai only to say that even Sabitri Rai carves out these distinctions in jurisdiction. Therefore we say the judgment in Sabitri Rai is good law, right? Because 178 is mentioned, and therefore we also say that we rely on Vishwanath Gupta. Further saying why 178 applies, right? Because Vishwanath Gupta says when there is uncertainty as to in which of several local areas an offence was committed or where an offence is committed, partly in one local area and partly in another, or where an offence is continuing one and continues to be committed in more local areas than one, or where it consists of several acts done in several different areas, it may be inquired into or tried by a court having jurisdiction over any of such local areas. Therefore 178 has to be construed. So we said we do not fall under 177, we fall under 178. Therefore your courts in Sikkim have jurisdiction, therefore you can grant transit bail. And fortunately we got transit bail, right? And eventually when the court case went to South also, the South Indian courts were also not very clear, keen on granting such a thing. Now let's go to anticipatory bail. This is another very interesting case we did. Anticipatory bail, all of you know. I'm not going to go deal with the provisions. Let's go directly to the problem we faced. A was apprehending arrest. Anticipatory bail application was filed. The prosecutor, when we filed this application, said if you see 438, 1A and 1B, it says the prosecutor has to be heard before the bail is granted and the fellow has to be produced before the bail is granted. Very difficult problem, because if the person is produced, every possibility that they will delay the hearing and then pick him up, and then the anticipatory bail application fails. Now what did we do next? Very serious problem, very high stakes. Our research, when we that time I told you please make your list of dates on anticipatory bail. This is what led us. This is the conclusion that it led us to. 1A and 1B in 438 was inserted by an amendment of 2005, right? We noted that protests happened. We noted that due to this protest, this 1A, 1B amendment was never enforced. We also found the 203rd Law Commission report said that put this in abeyance. But magically, if you see your CRPC right now also, right now, your CRPC will have 1A and 1B. So the hearing started, prosecution said no, 1A, 1B will apply. The Honorable Judge said no, 1A, 1B applies. We showed all these. We showed them the Law Commission reports. We showed them the judgment of the Supreme Court that decides on anticipatory bail also, noting that it's kept in abeyance. And therefore the court said, okay, there is no requirement for 1A and 1B to be compliant right now. Right? So this was the court's view. Can you see this? In response to the application of the prosecution seeking the presence of petitioner under 438 1B, Learned Counsel for the petitioner submits that although the CRPC Amendment Act 2005 came into force, Gazette notification excludes the provisions of this, right? From the aforesaid amendment, Section 38 of the Amendment Act pertains to amendment of 438 and its proviso. It is further submitted that due to a major hue and cry raised pan-India by various bar associations with regard to the proposed amendment to Section 438, the enforcement of 438 was put on hold by the Ministry of Law and Justice, and the Law Commission was thereafter requested to study the implication. The Law Commission, vide its 203rd report, observed that Commission has concluded that it is not necessary to have the proviso inserted in 438(1) and recommended its omission, since it was of the view that when the applicant appears in court in compliance of the court's order and is subjected to court's directions, he may be viewed as in the court's custody, and this may render the relief of anticipatory bail infructuous. The Law Commission accordingly recommended the omission of subsection 1b of section 438. Therefore, Learned Counsel for Petitioner submits that in light of notification 636/2006 and the recommendation of Law Commission, the presence of the petitioner in the court during the hearing is not necessary. So therefore, because of that, the anticipatory bail application was heard on that day and he got bail that day itself. 438(1)(b), had it been allowed that day, this fellow would have come to court, he would have been picked up outside by the police, and that anticipatory bail application would have become infructuous. Now, the biggest problem as law students is this 2005 Amendment Act has again reared its head. It's back under BNSS. So unfortunately, all that hue and cry that the bar associations did and the effort the Law Commission put, it has impliedly come back. So now you are again stuck with this ghost, and this is a very dangerous ghost. Now thankfully now I don't have to do this anticipatory bail again. But now if the circumstances are different, now if the same thing would have come to me, I'm in a handicapped position. Now, as far as other important provisions are concerned, before I go to Arnish Kumar, let me just go to ocular and medical evidence, right? So, during a criminal trial, तपाईको के हुन्छ, medical report ले भन्छ injury नै थिएन or injury थियो भन्छ, witness आएर भन्छ injury थियो थिएन. So, you will have contradictory, right? So, what does the Supreme Court say over here? Supreme Court's view when there's conflicting, views on evidence on ocular, eyewitness and medical evidence, it says that it is tried that where the eyewitness account is found credible and trustworthy, medical opinion pointing to alternative possibilities is not accepted as conclusive. Witnesses, as Bentham said, are the eyes and ears of justice, hence the importance and primacy of the quality of trial process. Eyewitnesses' account would require a careful, independent assessment and evaluation for their credibility, which should not be adversely prejudged, making any other evidence, including medical evidence, as the sole touchstone for the test of such credibility. The evidence must be tested for its inherent consistency and inherent probability of the story, consistency with the account of other witnesses held to be creditworthy, consistency with the undisputed fact, the credit of the witnesses, their performance, etc. The probative value of such evidence becomes eligible to be put in scales for a cumulative evaluation. In short, what the court is saying, the ocular evidence will always prevail over medical evidence. But the court is also creating an exception, right? So I'll tell you one case that we did was, my client was accused of beating up a fellow on the head with a rod. Eventually the medical report did not find any injury on his head. So there again you see, right? Because the medical report clearly contradicts the statement of the victim. So the victim's statement now assumes a lesser importance than the medical report, because it was of a grave weapon. So therefore, when you balance ocular and medical evidence, please be careful on how you balance the two. Now 145 CRPC. I'm teaching you 145 CRPC because this is a provision that is sometimes used, but I think it's one of the most important provisions when you are a civil lawyer also. Because के हुन्छ भने family को झगडा हुन्छ, civil suit जानु अगाडि नै, some family members try to जबरजस्ती take possession, right? Or say you are a tenant, the landlord will जबरजस्ती forcefully take possession. Now what happens if you directly go to civil suit? The law is clear. You cannot ask for a final relief in the form of an interim relief. So you cannot say मलाई पहिल्यै possession दिनु भनेर. You are stuck in a back foot नि. Somebody has already taken possession of your property, and after that person's taken possession, that person says go to civil court. So 145 comes to your aid in that manner, right? So 145, the Ram Temple judgment has a whole chapter on 145. The key ingredients for 145 being that you should file that application within 2 months of being dispossessed. That's your limitation period. Number two, 145 does not determine who has the title or who has right to that property. The district collector is only supposed to ascertain during those previous 2 months who was in possession and who forcefully took possession. And third is there should be breach of peace. So you will come across many instances where your family ko beech mein hungcha, you file a 145 petition, then that person will come and say, I know you're the joint family property, I have a right to it. That's the go-to defense sometimes. But the law over here is clear also. If you read all these judgments on 145, they say that the ownership, right to property, co-ownership, all that does not matter. You only see who was in physical possession at that time, and if the physical possession is established, then the DC has to restore that. Alright? Now, the other point is what happens if the DC district collector cannot ascertain who's in possession. The court then also comes to an opinion that if you cannot decide who's in possession, then you attach the properties and you tell the parties to go to civil court. So this is a good stopgap measure for civil suits, because people will take possession and then tell you to file a civil suit, right? And you cannot ask for interim relief, final relief through an interim relief. Now another big question over here is this. You will have criminal cases where forensic reports are prepared, and this is a very important judgment. Last time in High Court I argued this only. I don't know, it's a judgment still impending, but my key contention here was the blood-soaked clothes, the weapon, etc. were seized, but they were sent only a month later to RFSL. That was my first key contention. My second key contention was that when this, these items were sent, it is important that there is a chain of custody document. The document in essence shows who was in possession every time from the time it went from the Malkhana to the RFSL and back. So the reason why I stressed on that is because in 2023, the Supreme Court had a similar case. DNA report here. DNA report was used to, make sure that this person was guilty of the crime. But the Supreme Court then relied on the guidelines of the Central Forensic Sciences Laboratory, which has detailed, guidelines on how that item is supposed to be packed. It should not be sent without delay, and a format chain of custody document. So when all those things were not allowed, right, then that means that entire DNA report was also discarded. Now, dying declaration principles. Now this is also another interesting thing. You guys have read 32. Dying declarations principles, why it's important is there's this one of these landmark judgments of the Supreme Court called Pani Ben that spells out a series of guidelines, or what should I say, points on dying declaration, right? They say that dying declaration can be the sole basis for a conviction also, but they also say do exercise caution. They say that when the court has to scrutinize the dying declaration carefully and must ensure that declaration is not the result of tutoring. Because see, the point is that person has already died, no? So you cannot come and ask that person. So the tutoring, you have to check on this, Then you have to make sure it was voluntary. Whether he was conscious or unconscious, you have to check. And it also says merely because the dying declaration does not contain the details as to the occurrence, it is not to be rejected. State of Maharashtra, they are also saying equally, merely because it is a brief statement, it is not to be discarded. Normally, see, point is, this is 32 32 is not only applicable in criminal cases. 32 ko the subsections is not only a criminal case where somebody is murdered, no. In fact, we did a civil suit where the other provisions of 32 apply, right? So the father dies, the same thing, the daughter wants to be declared as the daughter of A. What do we have? Person's deceased. But we come across these matrimonial proceedings between the father and her mother. Kyo matrimonial proceedings mani, pleadings mani, he never denies he's not the same person. In fact, in several pleadings he signs also this alias this one. We then rely on 32 itself to show that even that is a admissible evidence under 32, and therefore you can establish a relationship. So when you read 32 of Evidence Act, please read it more than just, some dying declaration in a criminal case. Right. Now the next interesting thing is confession to medical officer in custody. See, the reason why I'm directly going to criminal case principles is, criminal cases, unlike civil suit where you're filing plain written statement, there's that, or multiple miscellaneous applications hearing. Criminal cases, charge sheet comes, immediately they'll start cross-examination of witnesses. Right? Then after that, your DW, etc., 313, final hearing. So, cross-examination is a skill you will learn by doing it yourself. But these principles are important because you'll need it in your final hearing or appeal. Now, this is another interesting case. What happened here was, this also I argued a few weeks back in High Court, I think more than a month back. Okay. This fellow was caught at 11:30 a.m. by plainclothes policemen. Arrest memo was prepared at 4:30 in the evening. This fellow was taken for medical examination at 2 o'clock. Medical examiner in his report says, oh, this guy confessed the murder to me. Right? So then when that person comes, he again says, oh, malai the confess kariyo. Unfortunately, over here, that confession made to the medical officer was also relied on in the impugned judgment. Because the arrest memo showed that the arrest happened at 4:30 in the evening. At 2 o'clock, he was not arrested. I went to the Honorable High Court. Then I said that, it's the period of restraint that is counted as arrest for exclusion of confession under 25 and not the formal arrest one. On that point, the Honorable High Court was in agreement, and further we showed this judgment, if you see Allah Rakha versus State of Gujarat 2024. It's the same facts. Confession made to a medical officer and then they use it as evidence and the Supreme Court excludes it. Now, the other point I raised was this only. What do you formally construe as arrest? Is it the arrest memo? Of course not. Otherwise, the High Court would have, Honorable High Court would have allowed that confession to the medical officer. The Honorable High Court, I also produced this judgment called Perumai Raja, where it talks about this only. They say, the words person accused of an offence and the words in the custody of a police officer in section 27 are separated by comma. Thus, they have to be read distinctively. The wide and pragmatic interpretation of the term police custody is supported by the fact that if a narrow or technical view is taken, it will be very easy for the police to delay time of filing of FIR and arrest, and therefore evade the contours of 25 to 27 of Evidence Act. Thus, in our considered view, the correct interpretation would be that as soon as an accused or suspected person comes into the hand of a police officer, he is no longer at liberty, is under check, and is therefore in custody within the meaning of 25 to 27. Same, right? 4 o'clock arrest memo ma banyo, medical officer 2 baji lansa, Allah Rakha, and this clearly settles the law. Honorable High Court was of the similar view, so I think this is something the Honorable High Court will now for sure decide. Right? Now, the other points I was supposed to discuss with you is okay. Last few I'll just discuss because I know we are getting late. Now see, one more point that was very interesting is, this was a case of the Honorable High Court which I had argued I think last year. Here. Alright. So here what happened was, this chap was picked up. See, I don't want to talk about whether he was guilty or not, but the facts of the case was, this guy was picked up, arrested, and then a trial took place, convicted, sent to jail. The file comes to me from Legal Aid as a pro bono counsel. My colleagues there, 2 of them, Prerna and Somaya, made the list of dates. First thing they tell me is, there's no case. No case. He is as good as convicted. Appeal dismissed. Then we sat and said, why don't we look at the date of offence? Alright. Now what finding we came to was ni arrest hundakhiri accused was adult, so that's why the police picked him up, trial happened, but date of offense was when he was a minor. He was a minor. We filed that appeal file gardakhiri, it turned into a huge issue, right? Because the Honorable High Court had a separate procedure. They were of the view that once a plea of juvenility is taken, it has to be sent to the JJB and the JJB will ascertain. But you know what happened was 2023 there were judgments of the Supreme Court that said that there's a distinction between ascertaining juvenility under the JJB and the court. If an application is filed before the court has to make an inquiry. So what did the Honorable High Court do? The Honorable High Court passed an order, said conduct an inquiry. Inquiry was made. Then again there was some confusion, mathematical confusion on the date of the age at the date of the offence, and then it was sent back. Now here I was saddled with a bigger problem. The inquiry report also said that he's an adult. So then I said, my lords, then kindly permit me to go to a final hearing and also file objections to the report, right? So then we made a long final hearing, and then this judgment basically in the end talks about that only. It talks about two important sections of the JJ Act which you have to read even in criminal cases because it becomes all the more relevant. It talks about how is the date of this juvenility ascertained, and in most important section 9 says that you can raise the plea of juvenility at any stage of the appeal. That was the first question the Honorable Court asked me was, why are you raising the plea of juvenility? Did you raise this in trial? No. But then I said the provision and the law itself says that I can raise it anywhere. And unfortunately we did a final hearing, and after again detailed arguments on the report etc., the Honorable also court came to a conclusion that that person was a minor at the time of the offence, so therefore the court set him loose, right? But now the main important question here is, what happens when he is set aside, the conviction is set aside? Here the Honorable High Court and the Supreme Court is clear that only the conviction, the time is set aside. The conviction is more or less upheld, right? But also remember, you cannot convict a juvenile more than 3 years. That's why he was removed. He was, freed. Now, I've told you about 94 and 9. Now, I think I should tell you about default bail, right? So, how much time do you have? Okay. All right. Okay. Then last point, only default bail, because it's time. 167. That's the old code. Talks about default bail. Charge sheets have to be filed in certain offences within 60 days and in other offences within 90 days, right? So now two questions come in mind. Sometimes what the police do is they'll file the charge sheet just before the period is over, right? And then file the supplementary charge sheet later. Now the question is, do you get default bail or not? What do you think? Anybody? Do you have a right if the charge sheet is partly filed only and not a complete charge sheet? Anyway. So the point is, the two schools of thought have arisen here, right? So most of the times charge sheet is filed, RFSL report is not filed. Multiple high courts, same argument made by defense that supplementary charge sheet containing the RFSL was not filed, so therefore default bail should be granted. High courts have said nothing doing. The supplementary charge sheet being filed later containing the RFSL report would not grant you a right to default bail. Now, however, Supreme Court ma orko case ma ke bhako cha bhane chai they filed partial charge sheet and they said investigation is ongoing. That means investigation is not complete. Teti bela chai Supreme Court said then you give default bail. Because as far as that, you see, you have to understand the reasoning here. The other one mata the investigation is more or less complete. It's just the report being awaited. That's the reason why the courts are not keen on granting you default bail. But if the IO himself says investigation is still ongoing and filing, or part charge sheets, then you have a right to default bail. All right. Okay. Any other questions? Please ask me. Oh, and in 5 minutes now, duties of advocates and ethics also. Please see, remember this capacity building course that is made by the honorable courts is for you to transition from law school to practice, right? So there are certain etiquettes, because law is a noble profession. Forget jolly LLB, what anyone says. Forget what the public thinks. Understand the genesis of this profession. It was always a noble profession, and it's up to you to keep that noble profession. So when you enter the court, please bow. When you leave the court, please bow. If there are senior counsels who need to come and sit for a hearing, please greet them, please give them a chair, right? Because they've spent that many decades at the bar to deserve that much level of respect. If we keep a cordial atmosphere, then others will also follow that same thing. You will also be seniors, then your juniors will also follow. So it's very important that we maintain the dignity of this profession. Number two, you will see many lawyers engage in questionable practices. Contingency fees, number one. Number two, going to the police saying, give me this case. I would be very clear with telling you these are questionable practices which does not behove our profession, although some do it because it's their choice. But if possible, please refrain from it, right? And also, please be sincere. Your job is to assist the courts. The courts are already burdened with too many cases for them to be a master in your case. You have to be the master in your case. You have to streamline your case into a few lines, show what the main issues are, what the law supports you. That's your job. Rest is, whether you win or lose is not the job, because see, you have to understand, sometimes the facts are against you. Your job is to perform to the best of your abilities for your client, right? So in the hope of winning, do not try anything shady. You may win that one order, but from the next day onwards, that honorable court will always look at you with suspicion. And any arguments you make will be taken with a pinch of salt. They will second guess you. Once they second guess you, your reputation is as good as gone. So what's the harm in losing? You always have a right to appeal. Do not mislead on facts, argue on the law. I tell you, law is a very subjective thing, right? So you do not need to lie. Lying in an argument is useless. You may win a clever order, the other side will appeal and say you lied. Rather, you interpret the law as the way it is supposed to be interpreted. No. That is your best way to stay long in this profession, right? So, please follow these things, maintain a cordial atmosphere, right? And please be sincere with your work. And last but not least, please again, list of dates. I started with list of dates, I will finish with list of dates because that is the first thing I did, that's the first thing you also should do, and that's the last thing I do when I go home, and you should also be doing list of dates. Alright. Anyway, please, any questions? Yeah, it's an open floor. You can ask me anything outside this topic. So please don't ask me too tough questions because I've only read so far today.
So I think I must share my identity. I'm director of Sikkim Judicial Academy, and I've seen most of the participants are students from law college. So 3-4 members from bar. So I've heard today's deliberation. What I'm to say is now, when I was in college, I was also not able to catch up what deliberation is going on in any one of the seminar, especially the court proceeding. You are confined to understand the law in principle only. Today, you never went to police station, you never went to the court and see the contents of the FIR till today. How to draw, what are the parameters. So your study is confined to the principle till date. So therefore you are not getting any charm. in most of the deliberation, because you never implement the principle practically by yourself in the capacity of director, capacity of member of the bar, capacity as a lawyer, capacity as an advocate. So first and foremost thing is now, this profession as per me needs a passion. It's not like a government job. So how many now students coming off from Sikkim University, Adv University, Government Law College in a year? More than 50, 60. Now we have very limited senior chamber, like the learned resource persons is accommodating 3-4 junior member of the bar, and you will come and join. So you have to set up your mind right from the beginning. If you want to practice, then you may not get an opportunity to have the beautiness, comfort of the senior chamber. That is the first hurdle you have to surpass. The second thing is now, how long you continue with this profession. 80% of students already set up their mind to get government job. After having practiced for 3-4 years, most are female members of the bar. The tradition, the system, custom in our state is now, they are now required to discharge the responsibility as a female member of the family. How far you carry on this profession is another great challenge. So it is up to you how you convince to the member of the family, how you prepare a bowl. So this profession is very, very, I think, this is very important profession, because you are required to run the state government. Ultimately, you are required to run the, who runs the country, you know? The legal luminaries, great member of the bar, as per me, runs the country. Because as and when there is controversy in the country, that particular controversy will ultimately reach in the Supreme Court, and Supreme Court is the ultimate authority, will settle the dispute controversy with the assistance of the member of the bar, and member of the bar are guru of the bench. So therefore, now when I was in law college, I never enjoyed the opportunity like this. So therefore, I, in the capacity of director with my learned deputy director, convinced only with the Chief Justice, why not to provide an opportunity to law students and incipient member of the bar to have the deliberation from the bonding example of the member of the bar, who has now enormous experience and knowledge of practice in the bar. So therefore, I am not discouraging, but when you are a student, you have not set up your goal, you have not set up your achievement, you have not set up your future plan of action, what you will do. So therefore, the most important thing is now, you are required to implement whatever deliberation today deliberated by the learned person is required to be, try to implement it. So there will be exercise of now reading and writing only. But when you join the bar, you are required to implement yourself in the capacity of advocate. So this is very important profession, and when you join even in the department of the state government, company, farm, court also, as a judicial officer also. So when you know the law, you feel very comfortable to work every year. so that the good orator now the way you present that needs a long length of experience. So I do not want to bother you much. So why I am standing here is now, if you have any queries with the learned resource person, if you have any this confusion in your mind about your future plan of action, if you have any problem while preparing your exam, that too you can ask. So try to avail the opportunity of the learned resource person here. So this particular floor for I think 5 minutes is open to you. Thank you so much.
Thank you, sir. Now the floor is open for the discussions. Any questions, doubts and queries now may be placed in front of the resource person. If you have any questions, you can engage our learned resource person now.
Does the proceedings in courts in Sikkim and the courts outside of Sikkim differ in any way, sir?
See, I think that's a very good question because I have now been in all these courts, right? Earlier I would not have been able to tell you. I think you guys in Sikkim are blessed. Blessed because the trial courts in Sikkim are clean, the pleadings are in English, the arguments are in English, the judges are well read, and the disposal rate is fast. Now, why do I stress that the disposal rate is fast is because as opposed to a junior who's practicing in Delhi, a civil case will take decades to get disposed. You will grow white hairs and grow old before you understand how a case is to be tried, right? When you stay in Sikkim, within 2 years you will have seen a civil case disposed. You cannot beat the volume and the pace at which you are learning. I mean, that's a huge advantage if you can capitalize. And I would always recommend that you first practice the trial courts, procedurals, CPC, CRPC, I cannot stress enough, and completing a trial and then going to Delhi. You see the quality difference. The only thing that the Delhi lawyers have is they are hard-working, tenacious. They will work you, outwork you. When I first joined the chamber there, it was a firm. 4 o'clock I used to see, oh my God, ab to ghar jana hai types. 4 o'clock is tea break. People are going home at 9. Then after 9 they go home and they'll still work. They have a very hard-working capacity to Monday to Sunday. But as far as learning experience, please stay in Sikkim, learn the basics, then go to Delhi. Don't run to Supreme Court, yeah.
So you do recommend us to go and practice for 1-2 years outside?
Of course. You know why? You have a strict senior, you guys, I mean, to be honest with you, even I was casual. But the point is, Sikkim are slightly casual, it's a laid back, it's a like strict senior science number one. But more important than strict senior is त्यो professional streamlined way ma kaam garnu sikauncha. And the working hours are longer. If you can do that, then when you come here, you will not complain about long work hours. Because eventually, even if you start your own chamber, you cannot complain about long work hours. That is how the litigation profession is. You can't run from 9 to 5 and say, Dokan kona. Calm happens after 5.
Thank you, sir.
So everyone will ask one question each.
Hello. Good afternoon, sir.
Yes.
Good afternoon, sir. Good afternoon, friends. I am Roman Gurung, student of Sikkim Government Law College, as you know,
Yes.
10th semester. So my question is that, if we look judicial reforms and access to justice, from the pre-British institution, that time, only people who belong from Indian, they were punished, and after pre-independence, we have that case, Lalita Kumari was state of UP, where a police officer refuses to register FIR. So from that case only, if an information is received by a police officer which is of a cognizable in nature, then FIR must be registered. currently we have Article 39A, that is to ensure equal justice and free legal aid. That comes under Part 4
DPSP.
Yeah, DPSP. And Section 341 of BNSS 2023, Bharatiya Nyaya Suraksha Samhita, that is free legal aid upon the expenses of state government. We have like that things for the access of justice. But still, why senior learned counsel, they are sending juniors to plead those case laws?
I think I would beg to differ with you on that, right?
Yes, sir.
You have to understand a trial goes on for a few years. No senior worth his salt would send the junior on an important hearing date because the legal aid itself will not permit that.
Yes, sir.
Yes, if the other side says there's an adjournment, the junior goes. But you cannot, the person on record is the senior.
Yes, sir.
Right? So
Yes,
the
sir.
senior cannot abdicate that responsibility. He'll be taken to task.
Yes, sir.
So see, you will see multiple hearings take place. Out of
Yes,
10 dates, maybe 2 or 3 important dates are there, no?
Yes, sir.
So it's not that the senior will go every day because the senior will have 40, 50, 100 cases to manage.
Yes, sir.
Right? So if he knows something is not happening that day, he'll send his junior.
Yes, sir.
Yeah.
Despite having numerous law, but still people are not access to laws, access to justice.
See,
sir.
one contentious issue I'll tell you, which despite being ST, I don't know, I mean, that is a debate for another day. But this reservation system in jobs, the logic cannot be applied in legal aid as far as I say, because it is a very controversial issue I'm saying.
Yes.
The reason why I say that is I see with my own eyes people very well off applying for legal aid,
Yes, sir.
and where that money could be invested somewhere else. So I think the first step would be to actually have a creamy layer cap on legal aid, right? Only those who actually cannot avail legal aid should be getting legal aid.
Yes, sir.
But now, unfortunately, that needs reforms. That reforms may come in a time and place. That is not our task.
Yes, sir.
As lawyers, our task is we are like soldiers. We do our task, go home, rest. Policy, leave it up to the learned politicians, right? We can't be politicians and lawyers at the same time. Some do that, but for me, I want to be a lawyer's lawyer. I want to only litigate. I don't want to decide policy like that. All right?
Thank you, sir.
Okay.
It's not necessary that your question should be confined to law only. Any question? Any question?
Good afternoon, sir. So more of a question. I've also written in this feedback form. I wanted to know more about survival skills in the courtroom as well as this profession. Because Sikkim Shano state, we understand, but still we have a lot of skilled people. So how do we survive that, and how do we excel like you?
This is a very important point, okay? This is something that I think is not applicable only to litigation. It's applicable to the general public in Sikkim at large. You have to be a soldier before you can be a general. What I'm trying to say is you have to take instructions from a leader, do the grassroots level work, right? And then you assume leadership, no? So even when you join the litigation profession, you cannot say, I will be the boss and do everything myself. Everybody starts off as a junior because first they learn the basics. They learn the basics, then they move on to start doing their own, right? So surviving the courtroom also means first you work as a junior. And I have done my time. I have done hours upon hours, Monday to Sunday from 9, 8 in the morning till 3, 4 in the morning. But this profession, you need to put in the time, then only can you actually, adapt. There's no shortcut to, surviving, that I would say. You have to go through the grind. It's a very grinding profession. Ups, sometimes downs, sometimes. You just got to stay consistent. Alright? And make friends, enjoy it. Don't always think, more judge, more senior advocate, more yoga. No. Enjoy the day-to-day thing, then you will not notice the time fly. Enjoy what you're learning. Every case brings something new to learn.
Yes, thanks. It's not necessary that you can narrate Nepali also. Any question?
Good afternoon, sir. Good afternoon, everybody. My question to you is how minimum time it will take a person to settle in this field, sir?
I mean, see, I'll be very honest with you. People have spent decades as a lawyer also and still not mastered it. Some people have been blessed enough to do it at a shorter time, but the only common link to people who learn fast is you have to take up volume. You cannot refuse tough cases, you have to say yes to tough cases. The more complex the case, the better. That's how you learn fast.
There is a complex issue. You can see it. This is a very relevant question. Now, the moment you join as a member of the bar, the family member will expect and consider you as an earning member. So, nobody is coming out with the reality and convinced to member of the family saying that I am still in learning process. The moment you join in the chamber, you will be allotted small cone of the chamber and make you to read the IPC, CRPC, BNSS. So, family background is not relevant. The relevant is your passion. So you will start earning. Me consume, I think, more than 3 years to earn. So after 3 years, you will start getting briefs from your senior. But you must have patience, perseverance, dedications, spirit of sacrifice, devotion. So you have to concentrate. You kindly see, the moment you join, you should not develop your fickle mind. You have to concentrate in your profession, saying that. Kindly see the example of the tiger. Even if tiger is hungry, tiger will never eat grass, because he has to maintain his integrity as a tiger. So who is not requiring money? Everybody. So if you want to reach that particular destination and cite a bonding example of your family and the society, you have to have a passion. And you have to convince to your parents, family, saying that I am still in learning process. It's like an oak tree, after 12, 13 years you get. But if you continue in this profession, yes, I'm pretty 100% sure there won't be any scarcity of job. So your intention, your now goal, your achievement should be, I want to become a very proficient civil or criminal or constitutional lawyer of this particular state and replace someone else where there is a requirement of the society. So you must have patience. You have to convince to your parents, and you must maintain the integrity, discipline in your profession. So then you'll obviously become a driver in this profession. So I was an
Good afternoon, sir. My name is Suman Rai, and my question is, how can we handle the pressure regarding the case inside the courtroom?
Pressure?
Yes.
Pressure.
So, before I started litigation, this is a very funny story. I was also in the state karate team and I played national level kickboxing and karate, right? So what I noticed is litigation and sports are very similar. You will face the pressure, right? And initially the nervousness is there, but as you keep doing it on and on, the nervousness reduces. And that's when you find, it's called finding your feet. Tabele first argument हडबड आउँदै गर्छ 20 आर्गुमेन्ट गर्नुहोस् 30 आर्गुमेन्ट गर्नुहोस् 40 आर्गुमेन्ट गर्नुहोस् एउटा कामनेस आउँछ एउटा फ्लो आउनु थाल्छ इट्स अबाउट फाइन्डिङ योर फ्लो डोन्ट वरी डोन्ट टेक स्ट्रेस एभ्रीबडी गेट्स स्केयर्ड भुँडीबाट चिसो हुन्छ सबैलाई मुटु ढुकढुक हुन्छ तर त्यो गरी बस्नुहोस् त आफै स्मुथनेस आउँछ consistency गर्नुहोस् and I guarantee you if you continue doing multiple arguments you will automatically find your own flow. You have to find your own flow.
Thank you, sir.
Welcome.
Good afternoon, sir. My name is Miriam Masupa, and my question is, could you give us some suggestions for us students who will be appearing
for All India Bar exam?
All India Bar exam? I think that's the least we should worry about. Although I don't think I should be saying it. It's a closed book, I mean it's an open book exam.
Yes.
My formula was simple. I looked at the syllabus, looked at all the laws that are in the syllabus. I took that effort, but I bought a suitcase. I carried all the barracks in that suitcase. I bought 2 MCQ questions on AIB, those big books. I practiced those MCQs. Then on the day of the exam, I went, I gave it, finished. Simple.
Yes.
You'll pass it, don't worry. Main thing is not the AIB, is not the headache. The main thing is you have to be consistent in practice.
Correct, correct. Yes, please.
Good afternoon, sir.
You share your introduction also.
My name is Mingmayang Jinsepa from Sikkim Law College, 8th semester. I would like to know how was your first experience when you joined the chamber?
Chamber? You mean to say the Delhi chamber? See, when you're a fresher, it's always tough. Always tough, but there's a reason why it's tough. Is they're testing your spirit. They want to see what you're made of. And to be honest, when you join a chamber, especially in Delhi, nobody is going to be your friend. Even the clerks will speak rudely to you. When I used to go to the office, the clerks used to come, "Hey, Sangay." It's only later when they see how serious you are about your work, then they'll start calling you sir and all. Even your colleagues will not be your friend till you prove that you're hardworking. Their only merit, they will not respect you if you're an easygoing chap. So, first year it's always going to be difficult, but they want to test you. Even your senior will want to test you. If you fail there, then you have to push further.
No, this is just, I want to add one thing on top of the response given by the resource person. You can see it. So kindly see, when you are going to the chamber of the senior, meaning thereby you are coming with proposal to have a seat for you in the chamber. You'll get the chamber, means the place where your chair is going to occupy in the chamber, means in Delhi, means is 3-4 lakhs per month. Getting my point? Here in Gangtok also is I think question of not more than 50,000. So whether you are worthy of that particular 50,000 or not, the senior will examine you in 15-16 days. Long run ka gada hai ki nahi, the senior will examine what kind of quality, what kind of caliber, what kind of command over the language, common sense, presence of mind, good health. Kindly see, then whether you are good literature, hands-on computer, what kind of contribution you will provide to the senior chamber of the senior member of the bar, or chamber of the head of the chamber. That is relevant. If you are really diamond, getting opportunity, then they will definitely help you to sign it. Whether you are patient, any kind of contribution. Kindly see, everybody reads law book. Case paper, everybody reads. Suppose you can, senior induce you the responsibility to go through the contents of the brief. So everybody reads big briefs. What would be your contribution is what thing is not there inside the brief and what innovative ideas you have created and bring life and soul in that particular case is relevant. So you'll be worthy of retaining in the chamber. So obviously beginning now, even if you purchase the shoes and wears, then you won't feel comfortable. After some time only, you feel comfortable. So therefore, the same thing, the spirit of now, dedication, devotion, passion. So in numerous now things you are required to hear. Sometimes you may not able to get the taxi. Sometimes you won't find the mood of senior in proper congenial atmosphere, many things. So you have to bear right from the beginning. These are the circumstances I am required to face right from the beginning. So I am to do extraordinary things which has not been done so far by any one member of the bar. So that particular passion, that particular kind of attitude has to be developed by you. So next thing, short question मात्रै सोध्नुहोस् ल रेलिभेन्टको. Your introduction?
Hello, this is Advocate Rajshri Chhetri.
Oh, yes.
And my question would be, since this profession is a learning process, we all know, but my question would be like, what are the 3 basic elements or the points to become one of the successful lawyer?
Great question. So, see, there's one thing that I've noticed that the Sikkim chambers don't do what Delhi chambers do, right? Delhi chambers...
You can take your seat, please.
So, Delhi chambers, when a case comes to a chamber, the senior will allocate the case to a particular team comprising of 2 to 3 individuals. Now, once that case comes to you, that is entirely your responsibility. Nobody is going to spoon feed you. So the client will talk to you, the files will be with you. That's why again I go back to the list of dates. You make your list of dates, you draft it. Your senior is only going to settle that draft. And that too before he's a senior advocate. I've been with my senior before he was a senior and now he's a senior. And so you draft, you're under pressure to write a good draft because he's going to settle it. So what are you, basically now when I think about it, why was all this done is basically he was training us to be independent counsels. Right? So you've dealt with the client, you've drafted it, he's settled it. Now the only time he'll ask you about this case is when the matter is listed the next day. So what are you expected to do? You're expected to make a 3 or 4 pager brief note outlining who you are, what your case is, what the issues is, what the case laws that support you are, and you're supposed to brief him. Now when you do that, what happens is you're getting into the habit of arguing a case. So when you go before a court, you easily know how to argue because you've dealt with that pressure. And that's why I feel that practice in Delhi was important because everybody was trained from the very first day to make a look at the case file, don't just come to court with it, but that person was making a brief note of that case file and learning how to argue that case. So by the time you move out of that chamber, you know how to do that case, right? Because in Delhi you have a new kind of system which is not applicable here, the briefing counsel and arguing counsel system. The arguing counsel will only argue the case, the briefing counsel deals with the client and drafts, etc. So that really helped me. To be honest, I have a lot of respect for my senior because from the very first day I was made to draft, brief him, everything, research, whole was in my responsibility, right? And even the briefing was up to him. So after that you get used to it. But over here, unfortunately, I've seen, I'm trying to implement it, but I also have not been able to implement it where, somebody, the chamber's colleagues make the brief note and know the case and go argue themselves. But that is something that practice has to be brought here to increase the rate at which, like the kids were asking here, that's something that actually helps them learn. Sit at the chamber, make your brief notes. So that even if your senior says, go ask for adjournment and the honorable judge says, no, you tell me what the case is, you can argue the case in detail. That's happened to me multiple times. There was one instance in Supreme Court where my senior had filed a case for extension of the term of the retiring NGT members. Suddenly he's stuck in another court. He says, you go argue the matter. I had my brief note, 2-3 pages. I knew what to argue. I argued it. Immediately the bench of Justice Chandrachud, Justice Narasimha and Justice Pardiwala granted the extension. So see, that helps you to be there at the right spot at the right time. So that is a very important thing you guys can try.
No. Yes. Now my only one response is, now the moment you receive brief, you are a driver of the car. So why profession in lawyer, this advocate profession is not policies now? If you see the driver can drive only. If there is any technical glitches in the system, then the driver will always take shelter of the garage mechanic. So therefore, my suggestion is, when you are a driver, you are required to know the entire system of your vehicle. Don't take please saying that this is a computerized vehicle. Getting my point? So, like in abroad, there is no driver. So they are maintaining through algorithm to run the vehicle. So the standard of the practice is so high after the arrival of now information technology in 21st century. Now you are the bar member of information technology regime. Through that particular process only you can catch up the standard of the senior who practiced 30-40 years. Now time has gone, you have to argue by collating with the system of computer, with the bench. So therefore, if you catch up the system properly with the system of the court and update yourself with the help of information technology, then you will be a perfect lawyer. Therefore, I suggest you, like a driver, perfect driver, you should know the entire computerized system of the vehicle. Means entire integrate life and soul of the case. Means your senior can blindly endorse any one of the case. So that argument, it takes time. When I practice before the bench of the Honorable High Court of Sikkim, I was not able to now reach my voice properly before the bench. Then I asked my senior, "Sir, what is happening now? My voice is not coming out. There is a severe now, like a fever is in my body." He said, "Yeah, it is good symptoms. It takes time, but it's good symptoms because you are now making some effort to stay yourself and submit. Sometimes now legal aid counsel, some now senior will endorse any one of the case and they will sit behind to see your performance. And sometimes you feel uncomfortable. Why seniors are sitting here, all seniors are waiting, all are not going out. Can you keep my case in the last list of today's cost list?" So sometimes I used to do like that. So it takes time. Automatically now you can able to cover up. But again I request you, suggest you, have patience and do extraordinary things which are not available between the pages of the books, anywhere, even in the internet, and place it, convince to the court, keeping on the perfect shape of the cotton to the judges, politely submit your point. Aggressive argument is not necessary. Up to the point, don't kill court time, time of the client, time of other colleague of your bar member, and maintain perfect relationship with each and everyone. So that will go wrong way. Anyway, this any important questions you want to ask, anybody wanted to now clarify from law resource person? Any questions?
Hello, good afternoon, sir. Myself Sumiran Chetri. So my question is, sir, how effective do you think is Bharatiya Nyaya Sanhita and Bharatiya Nagarik Suraksha Sanhita and Bharatiya Saksham Adhyam that was replaced in place of IPC, CRPC and Evidence Act?
Like I told my friend over there, I want to be a lawyer's lawyer and not a politician. So I will not speak anything, controversial. But the only point I want to say is these laws are more or less same as the IPC, CRPC with a few additions here and there. So these things could have been done via an amendment rather than a whole new replacement. And that's about it. Otherwise, see, since IPC, CRPC, Evidence Act were good laws, these are also good laws. Just there may be small problems, due to the sudden change. That's about it. Right?
No, this the main purpose, kindly see. We have to see first the nomenclature of the statutory provision. Because now, kindly see this Lord Macaulay, when he enacted, kindly you have to see the historical background, then only you can make out. Otherwise, if you see cursory, you will find some changes only. No, first if you read the background, how much time was consumed to enact this particular law? Because you have never read. Kindly read it. I think the parliamentary committee, intellectual, elite class of the society Supreme Court judges, High Court judges, bar members, even the head of the institutions, they sit together, discuss, analyzed. So suppose the junior member of the bar prepared the draft, senior will obviously see so many corrections. The senior will never consider sitting with their label and try to understand how much time, how much effort, how much brain was used to prepare this particular draft. Had I been in his place, could I do the same thing as done by this junior? The senior will not think. So similarly, so you have to see the drafting committee drafts, the observation given, interactive now sessions held by them, then only you can understand the difference. Because kindly see from 1872 till date, they kindly see the capacity of their statutory provision even after independence. So the main reason for now bringing this particular statutory provision is now during the British regime, they enacted law for their protection only. There was no democracy. And the government of India, now the parliament tried to bring some element of democracy inside the statutory provision. So that amendment was not serving the purpose. So therefore, they brought out this particular enactment. My suggestion to law student is now, if you know the provision of CRPC, IPC and Indian Evidence Act 1872, make comparative table. Because you are required to refer the new provision of the law in your answer script instead of referring the CRPC, IPC, Indian evidence. Prepare the comparative table, you will get in the tips of finger, and read it properly. And if you want to know the reason for now this having new enactment in place of 3 previous enactment, you go through the historical background, the draft rules, drafting committee, now this interactive session, you'll get each and everything, then you'll find the differences. Otherwise, simply comparing, you'll not find any difference. Like Judge Swaraj said, 438, the anti-swift bill kindly see, even if amendment, what kind of now the pressure, what kind of now this compulsion was made by the provision of anti-swift bill. Accused was required to submit an application. Then after 7 days getting interim break, he was required to come in the court physically. Then if court now turned down the prayer of the accused, then there is a possibility of arresting the accused in the courtroom only, in court premises. Now all this provision now totally removed in this particular provision. Sitting at Norway, accused can submit an application of anti-swift bill. There is no question of sending summons to the PP. PP will get the information. Accused is not required to remain present in the court. Sitting at Norway, only accused can now get the final product of the hearing. So lots of now this like a zero FIR. If you had been to Bihar and some incident took place there, but considering the unhealthy atmosphere, you are not able to file the FIR. You can come lodge in a FIR at Sardar PS 0, then Sardar PS can send down, then take necessary action. So there is no question of delay and all these things. So the beauty of this particular statutory provision enactment has to be seen by going through the historical background, going through the legislative drafting committee intervention, interaction, all these things. Then you can rightly write in your answer script saying that these are the changes. I have seen the spirit of democracy in this particular enactment. So that has been justified by the legislative enactment of the parliament. So don't examine the contents of the book by seeing the face of it. So as a student, you have to write in that particular way. As a lawyer, more deeper now, study deeper now, thinking, interpretation is required. So last question. Look, the last questions. Only पसिना आउने गरी रिसर्च पर्सनको क्वेसन सोध्छु पसिना भएर मैले निकाल्नु पाउन यहाँबाट.
Good afternoon, sir.
Yes.
Myself, Deepika Sharma from Sikkim Government Law College. And my question is, what qualities do you look for in intern student when you take them as intern in your chamber?
Qualities. It's the same that I do every day. I'm passionate about law, you know.
You can take your seat, please.
For me, to be honest with you, law for me was a passion. I'll tell you honestly, I was an accidental lawyer, right? Even my friend Sajal was an accidental lawyer. We started law in our 30s. We never intended to be lawyers. But the first class we took jurisprudence, which nobody likes, I fell in love with this subject. So if you are looking for the qualities, number one is passionate about law, but passion is not going to get you everything. You also have to be disciplined, consistent, be able to work, you know, be sincere. Main thing is that, because passion only gets you so far. Some days are like this, you know. So the only thing that gets you when you're down is consistency, you know, ups and downs. So hard work, consistency, passionate about law, professional, very professional you have to be, right? So a lot is expected.
Thank you, sir.
Welcome.
So, lastly, this now. So I'm seeking permission to Susma Madam to close this particular session. So lastly, now we have come to the logical conclusion of today's session. So I, on behalf of Sikkim Judicial Academy, would like to offer sincere gratitude to the learned resource person who has come all the way, leaving his official and personal commitments, duly accepting the request of Sikkim Judicial Academy and deliberate on important topics of today's program. And I once again, on behalf of Sikkim Judicial Academy, on behalf of all lovely students present here and the learned members of the bar, would like to offer sincere gratitude to him, and is extremely grateful for sharing your precious time.
Right.
At the same time, I would like to offer my sincere thanks to the learned members of the bar, who, despite of now having n number of professional commitments, leaving aside of your personal commitments, come here and dedicated your precious time to the auditorium hall of Sikkim Judicial Academy. So your presence greatly honored this particular session. I once again, on behalf of Sikkim Judicial Academy, would like to thanks to all learned members of the bar present here. Yes, of course, my sincere thanks are always due to the students, lovely students who have come from your respective places. Of course, implied is the Government Law College. And in fact, it was my personal request to your learned Dean and the Principal of Government Law College to send you by sending a letter of request to participate in this program. And you always never now seek sort of excuses to come here. Always spend your precious time here and learn, I think, lots of now this topic and lots of benefit that you achieve from the deliberation of learned resource person. And in future also, I think through your feedbacks, you must express your desire to have some session in the Sikkim Judicial Academy, and I always welcome you and always encourage you to come as in we send an invitation to participate in any one of the program. Lastly, yes, my special thanks goes to the entire staff member of Sikkim Judicial Academy, of course the learned deputy director. Without having her here in this program is incomplete. The entire technical manpower, hardware, the electrician, the lineman person, and the Susma Madam who organized this program very wonderfully, and thank you all. With this now, my small sharing of words. I request you to join for photo session and then we'll proceed right for lunch. Thank you so much.